Wait, and one to the dispose of it.
My lord, this is a restoration application, my lord. I have filed, let it be listed.
Happy lordship in connection and can in connection with that. Can. The other one. Item number 1.
Well, one of the benefits of the YouTube, we get minute by minute what where lordships. So we were discussing the food that lordships are only, that part was not on YouTube.
Food. Yes. Why is this?
Well, this is been assigned.
Oh, I see. So when will you do it? What is this about?
Well, in fact, this matter was originally taken up by your lordships, and lordship passed an interim order and protected me. I am the appellant writ petitioner. And lordships heard both of us and passed an order asking 3 questions, formulated that. In fact, when this matter hearing was about to start, after seeing that, the other honorable division means released it after seeing the order of your lordship.
Some policy of the government.
Yes. Lordship. Yes. Lordship may keep it on Thursday. It will not, because we are seeking the similar order by your lordships. My contention it is similar. My other side's contention it is not similar. Only on that.
Very well. Thursday under the appropriate heading. This matter has been assigned to this bench by the Honorable the Chief Justice. Paragraph. On the request made by learned counsel for the parties, comma. List this matter under the appropriate heading on next Thursday, you said?
Yes.
Next Thursday, date.
28. Wait.
Wait, please, my lord. So this is for the limited purpose of my learned friend, my lord, indicating a judgment. This is my lord, section 9 and territorial jurisdiction. So it meet my submission. My lord. There's only one judgment I wanted to take. Yeah, 2018, my lord, Calcutta 332.
Judgment যেটা দিল তাইনি
Last page, paragraph 84. Report. Married.
Yes.
Milord, paragraph 81 is Milord, section 9 and how is to be Milord? Paragraph 81.
That's different.
My lord, it is.
That's
My
different.
lord, this is 2018 decision that I have relied on 2020, 23 and 24. Where my lord, Indus Mobile has been followed. My lord, here it has been, my lord, doubted, but thereafter, my lord, Indus Mobile has been followed subsequently by the Supreme Court.
Anything more?
No, my lord, these are my submissions. These are my very respectful submissions.
Issue. We have heard. We have heard learned parties, learned counsel for the parties at some length on the point of, this is purely on the point of jurisdiction.
On the point of jurisdiction.
The point of jurisdiction of the learned trial court to entertain the application under section 9 of the Arbitration and Conciliation Act, 1996, paragraph, list the matter under the heading for orders 3 weeks hence. Date the other.
Very deeply obliged, my lords. Grateful.
My lord, I appear for the petitioner, my lord. This is an application seeking a modification of your lordship's order. My lord, before I take your lordship through the order, my lord, this is regarding that mobile tower telecom infrastructure lying at Barashat. Lordship has held that since it's a commercial dispute, I've served. Yes, my lord. My lord, I have filed. In fact, they were aware. They yesterday contacted our advocate, my lord. We had a word. Tomorrow. Even
service.
Yes, my lord.
No, it doesn't really impress us.
My lord, then I'll give them notice, come back.
Yes. Give them notice. Show us receipt of the notice. Thereafter, if they don't come, that's different.
Is it my lord pleasure to keep it again next week? Because I had made a prayer, my lord, that on that is tomorrow, my lord. If they can, my lord, agree, we can go there and have it inventarized and removed.
We can keep it tomorrow in the morning, also the special case, if you are able to.
Monday again. My lord, in that
Or
case,
on Monday.
Monday, if lordship gives me an
Yes.
indulgence.
Affidavit of service filed in court today, we kept with the records. Stop. We are not satisfied with the service. Paragraph, let fresh service of this application be effected on the respondent and respondents. And a fresh affidavit of service be filed in court on the next date, paragraph, as requested by learned counsel for the applicant. Let this matter be listed again on Monday date thou, before the original side matters.
Very grateful, my lord. We'll do a hand service, my lord, to the advocate.
Crossover.
Led by Mr. Bachawat, is on his way. May I just start, my lord? This is arising out of an ex parte ad interim order of injunction. My lord, the order, my lord, will find from the memo of appeal. It's a short order, my lord. The principal grounds of challenge, may I just indicate, my lord, in short?
Let us read the order first, Mr.
Yes,
Mukherjee.
Yes.
Order is annexed to the memo.
Memo.
Yes, yes.
Yes, ma'am.
31st July.
Yes, my lord.
31st
My lord, may I, my lord, I'm being led by Mr. Pochavat.
Yes, yes.
Lord, before your lordship is troubled with the order, I'll just take 2 minutes to give your lordship the background. It'll make more sense. It'll make more sense, nothing more. Lord, I am the purchaser of property in Lake Avenue. I purchased it in 2000.
In
Not Lake Avenue, not around, or Lake Terrace side area. Now, Lord, I purchased this in 2023. There is a registered deed, records that full amount has been paid. Now, that property was owned by the Banerjees. I'll just use names here. It was previously owned by the Kaurs. Kaurs sold to Banerjees, Banerjees sold to me. They sold it to me in demolished condition. Building was demolished, I purchased it. Now, under the Kaurs, my lord, the petitioner before the trial court, which is IIM Calcutta, was a tenant in respect of roughly 500 square feet of space, comprising of 5 flats, which they were using for the accommodation of professors or staff.
500 square feet.
500 square meters, which is roughly about 4,500 square feet, 5 flats. Now, when Milord Kaur sold to Banerjees, they returned and became tenants under the Banerjee. Now, Banerjees, long before the sale to me, in 2020, entered into an agreement with IIM, saying demolish. And on demolition, some portions will be given to them. 75% of the area they occupied will be again given to them in tenancy. This is the agreement which we see. Now, so, my lord, IIM vacates, building is demolished, and then he sells to me without disclosing these facts. My deed doesn't have any such thing. All done. Now, my lord, suddenly we are hit with an ex parte injunction restraining construction, which is substantially done, and restraining us from dealing with any portion of the property. Firstly, he has no right over the entirety of the property. Second is, if you restrain the construction, you are not going to even get back whatever it is. Now, Lord, three factors over here. Lord, number one, we did not know anything about any of this. Number two, Lord, at the stage when I take possession, Lord, the building is already demolished. Now, few questions which arise before your lordship, Lord, just 2 or 3 documents, and then, Lord, with the order, it won't take very long. Lord, the point over here is, my lord, when I show your lordship the order doesn't consider urgency, it does not consider delay, and there are no reasons. That I'll show your lordship. But leaving that apart, my lord, the fact is that once, my lord, they vacated the tenancy and the building is demolished, the subject matter is gone. That's something the learned judge did not appreciate. But the law is pretty clear on that. Once the subject matter is gone, if you are a tenant which falls within the Rent Act, the subject matter is gone, whatever right you have is gone. On the other hand, if it is under the TPA, under a lease, which is subsisting, then the protection of 108 kicks in. But if it's a tenancy under the Rent Act, subject matter is gone, you have no right to claim possession, but I'm not even on that. Now, the important fact here is when they enter into the agreement, that's what the petition discloses, they agreed to give vacant possession, number one. Number two, thereafter, for 3 years, they negotiate. Banerjees negotiate with IIM Calcutta, which gives up its right in relation to the flats. And they say, give me compensation. Banerjees say, I will give you compensation. So it's clear I am not in the loop. I have not kept in the loop anywhere. Now, the compensation agreed on is that the Banerjees will not start a scholarship. 50 lakhs they will put in a fixed deposit, 50 lakhs in a bank guarantee. That's their pleading in the petition. I'm only going on the basis of facts in the petition.
The agreement was given a go by.
Absolute, complete. That's the pleading.
75% of that is given a go by.
It's now to be compensation, monetary compensation. There is some negotiation, some correspondence seems to take place, and they say very well. Now, thereafter, not very strange things happen. This gentleman says, I will create a FD of fixed deposit of 50 lakhs, and the rest I will give over time by way of a bank guarantee, and this will be used to make a scholarship for students coming into IIM. So apparently a draft agreement is forwarded by IIM, at which point of time, not the sparking of letter is at page 91. Please take that letter. Now, this is where, now, the strange thing is not the correspondence between 2023 and 2025 shows that he is informed that I have purchased it. He is not told I have any liability. They are corresponding. He gives up his right to the flats. Now they are only corresponding about the quantum of compensation and how it's to be paid. Now, the spark off is this letter, page 91. So, my lord, this is the Banerjees, the erstwhile owners, writing to IM. I regret to delay in replying to your email. Unfortunately, the buyer of the property is of the opinion that IM cannot claim any part of the property from him and has accordingly refused to pay me the withheld amount. Now, there is no withheld amount. I'll show your lordship. Full consideration paid, memo of consideration recorded. I have no withheld amount. And there was never any question. I was never told about these tenants. I was never told I have to pay. Now, however, if IM can appoint the company to be authorized entity to take over and manage the property, I will make the necessary contribution. So, my lord, this is clear collusion between the two of them. Where is the question of, my lord, I am appointing him to manage my property, which is sold to me absolutely and forever? Then, my lord, please see the next paragraph. Else, I regret that you may have to legally bind the new owners and take your share of the property. So, he says, go file a proceeding. So, my lord, it's in this background that they file the proceeding and get this order, my lord, which your lordship will find either in the memo of appeal or page 94 of this petition. Not the first page is only petition has been filed, grounds are there, petitioner pays for an order of injunction, heard submission, then not last line. Peruse the application which is supported by an affidavit and the documents annexed herewith. Upon perusal of the agreement of 31st January 2020, which is between IIM and the Banerjees, and the respondent numbers 1 and 2, it is seen from clause 9 of the agreement that there is an existing arbitration clause.
You are a party?
No,
to
no, no.
Section 9, no.
No. Not in the section 9, I have been implemented as a party. But I am not a party to that agreement. No, I wasn't even in the picture when it happened. It is seen from clause 9 of the agreement that there is an arbitration clause and all disputes shall be referred to arbitral tribunal. Now, this is the only thing which is there. From the materials on record, it appears that the petitioner is a tenant under the respondent number 1, but not is a tenant. He was a tenant, went out, building demolished. But the respondent numbers 3 to 6 are new purchasers, and automatically petitioner will be a tenant under them. Now, how does he get this? How will he be? As such, it appears there's no adjournment. Not 4 years, 5 years, 3 years have gone. How many years? 2020. 3 years have gone by. As such, it appears the petitioner has been able to make out a prima facie case, balance of convenience in favor. If at this stage injunction is not passed in favor of the petitioner, petitioner will suffer loss injury. And then, my lord, prayer is allowed in favor of the petitioner. Please see the order now. The respondent and their men and agents are restrained from making any construction on the property and also restrained from creating any third-party interest. Now, my lord, please see how these two are contrary to each other. If I am to be restrained from making any construction, he will never get his share, assuming it remains. So, construction could not have been restrained. That's number 1. Number 2, let me show your lordship that on their pleading, Lord, their right is only compensation. Lord, may I just show your lordship 5 paras from their petition to show the admissions?
No. What we are proposing,
Yes,
subject to hearing them,
my lord.
we don't see how construction can be restrained, what right they have. So that part will go. Regarding the other part, the petition is pending, go back and fight it out.
But perhaps not. Let me take that instruction. Give me 1 moment. Very well. Lord, I've taken the instruction, but not with this rider. His right is over 500 square feet. Under his
Square
pleading,
meters, square meters.
sorry, 500 square meters, Lord. And Lord, under the agreement, he is to get 75% of that area. So, Lord, 75% of
375.
of that, my lord, your lordship will not protect for the time being.
Yes.
But please say that your lordship has not decided
No,
this
no,
on merit.
of course, of course, of
The,
course.
not the question of vacating that part
Yes.
will be considered
What do you
before the
say?
trial court. My lord,
Have you
I'll tell you,
understood what
lordship,
we are proposing? Have you followed what we are
but just
proposing?
one sentence, if I may. Not whatever order your lordship passes, not please bear in mind, I'm not even a party to the arbitration agreement, but this is not, no order could have been passed against me. Please not.
We'll record that submission without prejudice to the maintainability of Section 9 against you. Everything is left open.
Correct. my lord.
Have you followed what we are proposing, madam? We are protecting for the time being your interest in respect of 375 square meter, which is 75% of 500 square meter. We are vacating the restraint order insofar as construction is concerned, and we are sending back everything to the learned trial judge for considering on merits.
Trial. Your Lordship, we are led by Mr. Shobhashai Chaudhary in the matter. Can we get back?
No, no. Then you should have sought an adjournment at the very beginning, madam. No, sorry. Issue.
Stepped into the shoes of the
Under challenge in this appeal is an order dated July 31, 2025, passed by the learned district judge in charge, South 24 Parganas at Alipur, in Miss Case Arb number 71 of 2025, bracket R-71, on an application filed by the respondent number 1 herein under Section 9 of the Arbitration and Conciliation Act, 1996. Paragraph. The brief facts of the case insofar as relevant for the present purpose, are that the respondent numbers 1 and 2.
My lord, in the appeal.
No, the Banerjees are?
Banerjees, I'm not responding, my lord, over there.
Yeah.
Over there, one and two.
Respondent numbers 1 and 2 in the Section 9 application, bracket in short, the Banerjees, bracket closed, had acquired a property somewhere on Lake Avenue.
Yes, my lord, I'll give your lordship the exact address. My lord, it's Lake Terrace, 218A, my lord, 218B, my lord, 218B, Hemanta Mukhopadhyay Sorry.
218, acquired premises number, correct?
Oh,
Premises number 218B, Hemanta Mukhopadhyay Soroni. It was Manukar Rastata. From the former owners being the cores. Stop. It further appears that IIM, on IIM Corona, Indian Institute of Management, Calcutta, bracket in short IIM, bracket closed, was a tenant in respect of approximately 500 square meters of area in the said property under the cores. Stop. After the ownership of the property changed and the Banerjees stepped in as the owners, the IIM became a tenant under the Banerjees. Paragraph. The appellant herein
Your Lordship, I was always a tenant before that.
Yes.
Banerjees came in later.
That's what we have said, madam. They were tenants under the cause.
Yes.
We have said so. You will learn. The appellant herein,
Lord, before that,
you are the
sorry to
Please.
interrupt. Before that, Lord, before the appellant comes in, they enter into agreement, no objection is given, and an agreement is entered into by which he will give up possession.
paragraph. It further appears that sometime in the year 2020,
Lord, 2018, they
18.
started negotiating, and 2020 is that agreement. That
sometime
will
in
Lordship will
the
get at page 27 from his petition.
sometime in the year 2020, an agreement was entered into by and between the Banerjees and IIM, whereunder IIM was to give up vacant possession of the portion of the premises that it was occupying and was to be rehabilitated in approximately 75% of the area that it was holding after the old building, after demolition of the old building and construction of a new building. Stop. Paragraph. The appellant herein being the respondent number, trial court, you are?
Respondent numbers 3, 4, 5, 6.
So who has
But
only
4,
one?
5, 6 are the partners of 3, which is the LLP.
The appellant herein, which is the respondent number 3, before the learned trial court, comma, the respondent numbers 4 to 6 being its partners, comma, says that it did not know anything about such agreement. Stop. It acquired the property from the Banerjees in
2023
in 2023
by a registered sale deed.
by a registered deed of sale, and it has paid full consideration money therefore. Stop. Paragraph. The further case of the appellant is that suddenly an ex parte order of injunction was served on the appellant, restraining the appellant from making any construction on the suit property and also restraining it from creating any third-party interests in respect of the suit property. Stop. The order was passed on an application under Section 9 of the 1996 Act, as has been indicated above. Paragraph, the appellant says that it is not a party to the agreement that was entered into by and between the respondent numbers, by and between the Banerjees and IIM. Stop. The appellant is not a party to any arbitration agreement on the basis of which a Section 9 application can be maintained against it. Stop. No adequate reason is recorded in the order under appeal as to why it was necessary to pass an ex parte order of injunction. Stop. The issue of delay on the part of IIM in approaching the court, or the issue of any legal right on the part of IIM was also not sufficiently adverted to, comma, or at all. Stop. Was not adverted to sufficiently or at all. Adverted to sufficiently or at all. Stop. Being aggrieved, the appellant has come up by way of this appeal. Paragraph. We have heard learned counsel for the parties. Stop. The petition is pending with the Section 9 application is pending before the learned trial judge. Stop. Insofar as the restraint on construction on the suit property is concerned, comma, we do not see how the how IIM could have obtained such an order. Stop. It appears from the documents on record that subsequent to the agreement of 2020 that IIM entered into with the Banerjees, comma, there was further negotiation and there was a fresh agreement / understanding / arrangement between them that in lieu of IIM giving up their right to any portion of the suit property, comma, the Banerjees shall pay compensation, monetary compensation to IIM to be used for instituting a scholarship for needy students. Stop. It prima facie therefore appears that IIM has no right in respect of the suit property and therefore no right to obtain an order of injunction restraining the undisputed owner of the property from making construction thereon. Stop. Hence, we set aside the order under appeal insofar as the same restrains the appellant herein from making construction on the suit property. Paragraph. Insofar as the other portion of the order is concerned, we are not inclined to go into the merits of the claim of IIM or the defense that the present appellant may have. Stop. We modify the order of injunction restraining the appellant from dealing with the said property to the extent that the appellant shall not deal with the suit property or create third-party interest in respect thereof without keeping apart 400 square meter area. Stop. We make it clear that we are not deciding anything finally insofar as IIM's claim to possess any portion of the suit property is concerned. Stop. That issue will be decided finally by the learned trial court upon hearing both parties and on exchange of affidavits if the trial court so deems necessary. Stop.
Along with all issues of maintainability.
Stop. The issue of maintainability of the Section 9 application against the present appellant is also left open for the learned trial court to decide. Stop. That is all.
Well, if Lordship permits me, Lordships have observed, prima facie IIM has no right because of that.
No, paragraph. All observations made in this order are prima facie and only for the purpose of deciding the present appeal. Stop. The learned trial court, while deciding the Section 9 application, shall not be swayed by or shall not take into consideration any observation made in this order.
I was only humbly submitting, if our submission also be recorded.
Yes, what?
This offer of scholarship, it was only an offer. It was not accepted. There was no agreement. It was that is what he did, and they were set up by, according to us, by Mr. Bachawat's client, that you give an offer, draft agreement was forwarded, and then they just backed out.
So he had
And
agreed.
then, my lord, this also goes, that also goes. Nothing transpires. Nothing happened. It was only an offer. They won't be able to show we have accepted it.
That's your pleading.
একটা জায়গা দিয়ে দিও যেখানটা ওই যে স্কলারশিপ বলেছি না, ওখানে একটা প্যারাগ্রাফ করে learned senior counsel for IIM says that the offer that was made by the Banerjees for paying monetary compensation did not fructify into an agreement, as such offer was never accepted by IIM. Everything is left open, Mr.
That's all right. 400, whatever that area, instead of the area, if Lordship puts it in flats, because the idea was, my officers were staying over there. And
No, but the 5 flats, we don't know what size each flat is. How can we say 5
That
flats?
is mentioned. The
that
size
is
of the
mentioned.
flats is mentioned.
That is mentioned.
But it has been converted into 75% of the
Because
total area.
the area, towards in the garage or in the rear portion, Lordship will find that at page 28. Towards the
But it
garage
can't be
or
done because
somewhere.
I
they
now
will
have a
say-
sanction plan. Lord, I now have a sanction plan now. Whether there can be 5 flats or 7 or 2.
Mr. Bachawat's client knowingly, purchased it, that entirety is tenanted. That is there in the conveyance deed itself. 5 or 3, whatever.
Very well, there is 400 square meters যেখানে বলেছি না, in terms of the agreement between the Banerjees and IIM.
In terms of this.
Add করে দাও. Good. আচ্ছা, প্রথমে by consent of the parties, appeal and corrected application. Disposed of.
Briefly.
My lord, this matter, my lord, I am appearing for the petitioner, my lord. The
For the respondent,
restoration application, my lord.
you are for both the respondents.
My lord.
He বলছে কি?
My lord, yes, I am for
Yes.
the respondent. my lord.
Yes.
My lord, this appeal has been
Restoration, my lord,
preferred
start of
against
three, my lord.
against the
Let us see what the
My
order
lord, my
is.
lord.
Order dated
10th July, my lord.
10th July. হ্যাঁ, এক কথা order. July 25.
Lordship.
Where is it? The last order we see is 14th February 25.
My lord,
মেমোতে কি লিখেছে দেখতো? কোনটাকে চ্যালেঞ্জ করছে?
10th July, my lord.
You are challenging 2225. Look at your memorandum of appeal.
My lord,
Look at the second page of your memo of appeal.
First page.
today, my lord, I am for my recording application, my lord. For the recording application of order dated 10th July 2025.
What recalling? Dismiss for default.
Lordship, my lord.
সেটা তো বলবে রে বাবা। Restoration application.
Lordship, lordship.
আছে?
My lord, this appeal should be heard, my lord. And because, my lord, I am suffering from the vehicle has been seized by my learned friend.
Yes,
They have
it will be heard. Let us
My
not restore, please.
as because I am suffering, my lord, for sake of rupees 1 lakh, they have.
Yeah,
seized
you're
my
ready
vehicle
to
of rupees
proceed with
5.
the appeal today?
My lord, today, my lord,
My lord, heard it, my lord.
Huh?
only for restoration, my lord, today.
We can hear out the appeal today
My
also.
lord, that would be better.
I am, my difficulty is not,
Other-
I have
Not ready.
lordship, my lord.
As because, my lord,
Next week we'll hear out the appeal.
Next, any day, my lord.
This is an application for restoration of FMA 734 of 2025, which was dismissed for default on July 10, 2025. Stop paragraph. Having heard learned counsel for the parties, we are satisfied with the explanation furnished for absence of learned counsel for the appellant on the day the matter was dismissed for default. Paragraph, the order dated July 10, 2025, is recalled. Stop. FMA 734 of 2025 is restored to its original file and number. Paragraph, Can 1 of 2025 stands disposed of. এবার appealটা দাও খালি। On the prayer made on behalf of the appellant, let this matter stand adjourned and be listed again on next Thursday. Under the same heading, retaining its position.
My lord, I shall be great.
আচ্ছা, অ্যাপ্লিকেশনে কেন আছে? ও রেস্টোরেশনটার জন্য। তাহলে সেম হেডিং না? Under the heading hearing at the top.
Very well, very well. Next Thursday. Very good. I am grateful.
So this is my appeal. Right? The last day when my lord had heard the matter, it had passed an order directing us to seek instruction with regards to the
Both parties to take
Yes.
instruction.
Well, with regards to the bank guarantees, Lord, I have a communication written by us to the United Bank of India and handing over them the bank guarantee either to encash it or will it to get it extended. Lord. So these are the communications. So Lord, according to us, the bank guarantees are with the bank.
হ্যাঁ, এরা করবে তো বাবা। Sorry, we have not followed.
With the bank guarantees, they had expired. So we had presented with the bank to get it extended by the party, upon which the party had communicated to the bank that there was an award by which there was a direction of releasing the bank guarantee.
Yes.
And accordingly, the bank guarantee is no more with us, it is with the bank. But another communication from the bank is also there with us.
Expired. Then, madam, how are you worried if the validity has expired?
Yes, my lord. But during pendency of this appeal, my lord, they are unable to release the bank guarantee, my lord.
Today, the bank guarantee is no more valid.
Yes, my
They
lord.
can't encash it.
Yes, my lord.
Then you forget about it.
My lord, kindly direction may be given to the bank to release the bank guarantee.
We will
my
do
lord.
so. We will do so. We will record. We will record that. What about interest?
I will not record my consent to it, but then I will grant that interest for that period, which was at page 79, for the period between 11th May 2012 to 11th March 2018. That was also the direction that.
No, so so we'll convert it into simple and finish off the matter.
My client is not ready,
Not ready?
my lord.
It will be a
The
court's order. Let your client go up to Supreme Court on this issue.
director of the company is present, my lord. That's why I am
No,
sending
whoever may be
present.
present, madam, be reasonable, finish off the matter. Otherwise, it will be a court order and you will have to go up to the Supreme Court.
One more thing, my lord. Their MSME rate of interest has also not been released, my lord. That is also not calculated.
This is not your appeal.
Yes, my lord.
This is not your appeal, madam.
That's why their prayer is for, my lord, to release the interest in the rate of compound rate of interest, my lord. My lord, they had appeared in the Alipur court also, my lord. They have never challenged the amount in the lower court, my lord, trial court.
We had, minute. Then we'll see.
Show us the law that compound rate of interest is payable. Show it to us.
My lord, kindly come to page 87 of the,
Show us the law. Don't show us any page.
my lord. My lord, in the MSME, my lord, in the MSME section 16, my lord, I will produce your lordship. That is, there is clearly mentioned that must be in the compound rate of interest, my lord.
Madam, you have not been granted at the rate of MSME. You have been granted at the rate.
My lord, kindly come to page 87, my lord. Kindly come to page 87, my lord.
Yes.
My lord, page 87, first para, my lord, in the ending portion of the first paragraph. My lord, learned arbitrator finds that learned arbitrator has not followed the provision of section 31(7)(b) of Arbitration and Conciliation Act 1996. At the same time, learned arbitrator has also not followed the provision of section 15 to section 17 of Micro, Small and Medium Enterprises Development Act 2006 at the time of passing the award in respect of the interest. On the background of the above noted decision, this court, after going through the provision of section 31(7)(b), finds that a sum directed to be paid by an arbitral award shall, unless the award otherwise directs, carry interest at the rate of 18% per annum from the date of the award of the date of payment, my lord.
But where is that compound interest part mentioned? 18% is there.
This legal provision is clearly reflecting to that the petitioner, Ria Chemicals Private Limited, is entitled to get award in respect of interest from the date of award, that is 11th May 2012, at the rate of 18% per annum. Similarly, the provision of section 15 to section 17 of the Micro, Small and Medium Enterprises Development Act 2006 is clearly reflects that the petitioner, Ria Chemicals Private Limited, is entitled to get the award of interest of arbitration award from the materials of the record. It is found that the period of non-payment of the award of interest is near about 5 years and 10 months, and it is crystal clear that the petitioner, Ria Chemicals Private Limited, is entitled to get the award of interest for the period of 5 years, 10 months at the rate of 18% per annum, and the said amount would be rupees 65,92,426. My lord, they have never challenged this amount, my lord.
That is why the appeal, my lord.
My lord, in the trial court, my lord, we have filed, my lord, kindly come to page 79 where this amount has been filed, my lord. The statement has been filed. They have never challenged this statement in the trial court, my lord. And there is no reflection, my lord, regarding the challenge of this statement also, my lord, in the judgment.
এটা সিএবি করছি না ডেট রাখছি 2 weeks নাকি Madam, we'll list this matter 2 weeks hence again. In the meantime, we'll also go through the records.
I will also,
You also consider what we want to see is whether the provisions of MSME Act will apply at all.
yes, my lord.
Because the arbitration was not by the council under the
Absolutely.
Act.
Facilitation council was not.
It was by an arbitrator appointed by you, both of you, parties. So therefore, we have to see whether the provisions of this Act will apply at all.
I will bring in their judgments
Oh.
also, will say that. if
Okay,
we
you
would have-
consider this point and come back.
Yes, my lord.
Isho, dekho. We have heard learned counsel for the parties, paragraph. Insofar as the bank guarantees in question are concerned, comma, learned advocate for the appellant says that the bank guarantees expired, the validity of the bank guarantees expired, stop. The appellant presented the bank guarantees to which bank?
To United Bank of India.
To the United Bank. Has it not merged? No.
Now presently it has merged. But at that point in time, it was United Bank of India.
That's right. To the erstwhile United Bank of India. কাশির সঙ্গে merge করেছে?
In bank.
Punjab National. To the erstwhile United Bank of India for renewal, stop. Upon the bank intimating the respondents, comma, the bank was informed about the award in favor of the respondents, stop. Hence, the bank has not renewed the bank guarantees which are lying with the bank, stop. The paragraph. The respondents will be at liberty to approach the bank for taking back the bank guarantees. Paragraph. Insofar as the question of interest is concerned, comma, learned advocates for the parties seek a little time to come back better prepared, stop. One of the issues that should be considered by the learned advocates is that whether or not the provisions of the Micro, Small and Medium Enterprises Development Act, 2006, apply to the present case, Act 2006, and in particular, sections 16 and 17 thereof, will apply to the facts of the present case. Stop. This we say because we find that the arbitration in the present case was not held by the Facilitation Council under the 2006 Act, but by an arbitrator appointed by the parties. Paragraph. To hear learned advocates further on the point of interest, list the matter. 2 weeks hence. Under the same heading.
My lord, after my client's construction, my client had already intimated the bank about the passing of this award and everything. My lord, the bank guarantee has not been released by the bank.
We have said you'll be at liberty to approach. So go with this order.
Okay. Right.
And if so, approach the bank shall.
Item 8, I am for the respondent contemners, my lord. This is my affidavit in opposition.
I for the petitioner, my lord.
Have you given him her a copy?
Yes.
When? Today?
No,
No.
long before.
Have you read it?
Yes, my lord. I read it.
এটা কবে তো ready নেই। Division means पता नहीं। This second copy is not ready, my lord. I'm sorry, my lord. I'm beg apology.
Banerjee.
I'm beg apology. I beg apology. I have not seen. It is my clerk's default. My lord may impose cost upon my clerk. He will pay it personally. That I can say. But still, I have,
What do you say to the affidavit of compliance?
it is not maintained.
My lord. They have taken the hearing, my lord. They have conducted the hearing. And that's all.
No.
Conducted the hearing
Order
and passed an order. Passed an order. That's all.
Let us see the order. What
I'm
order
coming
was
to the
passed?
order at page 27.
Hearing.
Page 26, madam.
Well, then there is no contempt, madam. If you are unhappy with the order, you have to challenge it before the appropriate forum.
Yes, already order has been passed. That has been
That
added.
is what we are saying, Mr. Banerjee.
And writ petition was
You
also.
may be, the order may be not up to your liking, but then nothing can be done in contempt.
My lord, they have conducted the hearing, passed an order. And this portion, my lord, was passed the order when I'm reading, my lord.
This is order.
Page 27, para 2, we have not gone into the merits of the disputes between the parties. The officer granting hearing to the parties shall take an informed decision in accordance with the applicable law and the rules and the regulations. And according to the law and rules and
Decision has
regulations
been
of the
taken.
HMC
Next
Act,
page.
my lord, decision taken.
Sit. Yes.
But no action has been taken, my lord.
We have not said of any action. We have not directed also. If decision has been taken now in your favor, if you want action on the basis of such decision, this is not the court. There is no violation, Ashok. Affidavit, today in course of the day, you file the second copy. On the undertaking,
But a fine may be imposed, madam.
no.
My lord, as
No,
per
pull
their
up.
order, my lord, page number
Yeah,
28, I kindly see the order portion. That the respondent have violated the HMC Act 1980 and KMC Building Rules 2009 as extended to Howrah, and as such, the respondent is directed to demolish the 5th and 6th floor, which has been constructed unauthorizedly, and also the deviated portion.
Who
of
was the respondent before the corporation? Who is this respondent? Respondent
Is also a error, my lord.
No, both of them were called on the day, right?
Madam, it may be full of errors. It may be a wholly illegal order. Go and challenge it if you're unhappy. On the undertaking,
12,000 square feet of unauthorized construction, a huge unauthorized construction.
on the undertaking of learned advocate for the the respondents to file another copy of the affidavit filed in court today, which is described as কোথায় এক copy বা কোথায়?
That is there.
Which is described as affidavit হয়েছে? Described as affidavit in opposition,
জায়গা পাইনি।
comma, this matter is taken up for hearing. Stop. Paragraph, we find from the aforesaid affidavit that who has filed assistant engineer in charge, comma, building department, comma, Howrah Municipal Corporation has filed, no, sorry, bhul boldam. That's okay, who has filed?
I'm giving both the copies.
Has filed.
Change it, exchange it by today.
You've given 2 copies now?
2 copies in a white paper, my lord. I cannot.
No, won't do.
I'm given, but I will exchange it, my lord, in course of this day.
the assistant engineer in charge. Has passed an order dated April 1, 2024. After hearing the parties, stop. This was precisely the direction in our order dated February 7, 2024, violation of whereof is alleged in this contempt application paragraph. In view of such order having been passed by the assistant engineer in charge, our order stands complied with. Stop. The content proceeding stands closed. Paragraph. CPAN such and such is disposed of. Paragraph. If the petitioner is aggrieved by the order passed by the assistant engineer in charge, he shall be at liberty to challenge such order in accordance with law before the appropriate forum.
But still, we have done call them to give an inspection and immediately cause demolition. That we have done.
Very well. File the second copy today.
Immediately, today.
Your Lordship. Your Lordship, in this matter, I'm led by Ms. Ujjani Chatterjee.
Yes.
However, she'll be in court by 1:32 because she's on her way to the court. So, Lordship, if the matter can be kept at 2 p.m. Today.
No. Urgency is yours. Every
Yes,
time you
yes.
come and say that they are not there.
Yes,
Let us hear Mr. Banerjee. What is the problem? You have completed. We have to only hear him. He will be only giving reply.
Yes, if we have any reply, then we shall.
So you make a note.
Yes, Your Lordship.
But I did not open my argument yet. My
Oh.
lord's desire was
No,
that my learned friend should argue first.
Haven't they argued?
They have argued.
Huh.
They have argued.
Who is the appellant? You.
No,
No,
my
no,
learned
we are
friend.
the.
Naturally, so
yeah.
they will argue first.
Yes.
Now you argue.
Lord, may I file the notes?
Mr. Banerjee,
Yes, Miller.
let us not have it piecemeal. We'll record that they are in some difficulty. We'll just say not today. Adjourn for the day.
Should I file my notes of argument today, or I'll keep
Notes
it?
of, you keep it with you.
Right.
File it when you.
Right.
Your Lordship, I think Ms. Chatterjee is there online.
That won't help. We are not going to hear her virtually. She has to come and argue here. Learned arguing counsel for the appellant is not available today. Stop. Paragraph. Mr. Banerjee appearing for the respondent is present. Paragraph. Let this matter stand adjourned for the day.
This is the matter. The appeal is from an order passed under Section 8 of the Arbitration and Conciliation Act, which was rejected. appeal was preferred. There is a stay on the suit. On the last occasion, after hearing me for some time, my lords were of the view that perhaps we should go for mediation. And
Yes. What is the
my
instruction?
my instructions are we are agreeable to go for mediation. The appeal may be kept alive in the interim order for some time.
Yes, yes, naturally. Yes, Mr. Shah, what's your instruction?
My lord, my instruction is, my lord.
My lord, not at this stage, my lord. Kindly let us respond. Kindly hear us.
What do you
Yeah.
know?
My
Do
lord,
you think this is a joke or what? This is a joke or what? We'll hear you, and then at the end of the hearing, we'll refer you to mediation.
not like that, my lord. Not like that.
Either you agree or you don't agree. Please tell us clearly.
No, my lord, not at this stage. Not at this
Ma'am,
stage.
at this stage, বুঝতে পারছি না. Anyway, we'll hear the matter.
My lord, only
And
thing.
keep it next week, my lord.
আচ্ছা.
Because today, since we had agreed to mediation, we thought
দেখি আগের দিনের অর্ডারটা দাও তো.
yes, there was a formal order passed. But let it be recorded then that they are not agreeable to go to mediation.
My lord, not at this stage, my lord.
Well,
Not
at this stage, I don't know what it means. After
I will, my lord. I will try to impress, my lord.
Ms.
Lord, fraud
Mukhopadhyay,
cannot be, my
at this stage has no meaning in the context of what we are suggesting. Just don't go by what your client says. You're a counsel. You're a courts officer as well.
my lord.
Exercise your discretion, your wisdom. We don't appreciate your stand. Esho, likho to.
Next Tuesday after we
Huh?
Settlement to হবে।
Settlement.
Uh,
My lord, in that case, my lord, we can go for, we can try, but my lord, that is what, because it appears, my lord, that we are trying to scuttle mediation. No, we are not. We are not, my lord. Since it fell from your lordship that your lordship is not appreciating our stand,
correct. Correct.
we can go for mediation, my lord, but my lord,
We'll adjourn it for a month. Continue the interim order, come back. You may succeed, you never know.
my lord will send it to the mediation
Yes,
center.
yes. Issue. Read order dated August 7, 2025. Paragraph. The parties have agreed to go for mediation, as has been told to us by learned advocates for the parties. Paragraph. The member secretary of the High Court Mediation Center is directed to do the needful so that the disputes between the parties are placed before a trained mediator. Top paragraph. This matter will be listed again after 4 weeks. Bracketed date ta diye daw ekdam. Date ta diye daw. 4 weeks, comma, when the mediator shall file his final or interim report, comma, as the case may be. Stop. Paragraph. The interim order that is in operation shall continue 4 weeks কবে হচ্ছে 18 September.
But it was not a qualified interim order.
Oh, it was not. Shall continue. So matter will be listed on the 18th.
Very grateful to my lord.
এটা রাখো।
এটা তো খালি রিপোর্ট করবি।
Item 11, I am for the appellant, my lord.
Yes, please do it. Other side will not appear.
Well,
They have never appeared. And the advocate has retired also from the matter, perhaps.
He has retired, but they are pursuing this for the executive court at Alipur. That is what they want to do, but here no one is coming.
Let us see the impugned. What is it, a decree or order or what? Decree.
Well, what I have done, I have prepared a short list of deeds. Because the matter is of
advocate.
the agreement is of 9.
Ask the department, our department, to serve a notice on the respondents.
Substituted heirs.
No, why substituted? Address is not.
No, this was before Himanshu Bharadraj. He expired. We took after 5 years we came to know. We took out an application for substitution. It was substituted. Memo of appeal was also corrected. This is a fresh memorandum of appeal. So it has to go before the son, wife or name, no. Son and
Whoever it be, whoever it be.
from the department.
হ্যাঁ এত নোংরা ওটা না আমি হাতে
সাবস্টিটিউশনের অর্ডারটা দিনা
এটা দিও না ওটা
অর্ডারটা আমি জজ সাহেবকে বলি ব্যাকশিটটা কোথায় ব্যাকশিটে এই জায়গাটা থাকবে ব্যাকশিটটা তো substitution allowed the
এইটা
kindly goes back to order dated February 27, 2025.
Learned advocate for the respondents produces copy of email.
The February 27, 2025 milestone comes to that order. Two applications were taken up together. One, the change of name of the appellant, and second was for substitution.
Now, who are the respondents on record?
Hillol Bharadwaj,
মেমোটা কোথায় কৌশিক মেমোটা পেয়েছিস
the son, Hillol Bharadwaj.
And only the son?
Wife predeceased.
No. Three sons.
Three sons. They?
খালি হিল্লোল আছে হিল্লোল and others আছে ও বলছে আর কেউ নেই আমার এখানে মেমো নেই
Well, kindly takes paragraph 4. My application for substitution, these were there. Paragraph 4 for my substitution application. Hillol Bharadwaj is the son.
back side of this page হিল্লোল
Hindol is another son.
মুঘুর
Hindol. No, backside.
এই লেখো
Backside to the end.
in our order in our Burana, in an order dated June 17, 2025, recorded by a coordinate bench, of which one of us was a member, bracket আমার নামটা দিয়ে দাও, bracket closed. It was recorded that it was recorded that the respondents are not willing to contest the present appeal. Stop. This recording was on the basis of an email that was produced by learned advocate for the respondents, whereby the respondents instructed their learned advocate not to proceed further. Stop. Paragraph. We are of the view that a notice should be served on the substituted respondents to obviate all future possible complications. Paragraph. The registry is directed to serve notice on the substituted respondents whose names would appear from the cause title of the memorandum of appeal and file service report before us on the next date. Paragraph lists the matter. কত address আছে ওখানে ওদের?
কলকাতায় সব তো,
Address বলতে কোথায়?
সব কলকাতায় তো।
2 weeks will be sufficient. 2 weeks. List the matter 2 weeks hence. Date টা দিয়ে দাও. So that we are sure that they don't
Yes,
want
yes,
to
yes.
contest.
Only merely what Mr. Bhattacharya has given, he was appearing, Kaushik Bhattacharya was appearing. I was also, someone may come later on and say,
রেজিস্ট্রি জানবে কি করে অর্ডারটার কথা? হ্যাঁ, তো তোমাকে পাঠাতে হবে। রেজিস্ট্রিতে কাকে দেবে?
নামটা দে।
এমন না হয় যে ও বলবে আমি জানি।
লিস্ট অফ ডেটস গুলো তো রইলো, লিস্ট অফ ডেটস গুলো রয়ে গেল ফাইলের মধ্যে, ওগুলো টেকেন হবে।
In item 12, I am for the respondent. Or your lordship, kindly see your lordship's earlier order, my lord, once, 5th August order.
ওই আসছে।
বলেছিস?
But this is our appeal.
Start.
Man. Well, the
Paper book is there.
paper book, my lord, one paper book is filed by my learned friend, and my lord, I have filed a supplementary paper book,
I
which
see.
includes the statement of claim and my lord, the
Very well.
my lord, kindly for a moment, my lord, turns to my lord, the award of the arbitrator.
Oh, this
Kindly
is 37 appeal.
page
37 appeal.
37 appeal, my lord.
37. Well, kindly takes page number 186 of the first paper book. Sorry, but I'm led by Mr. Man. না জাস্ট শুরু করছি আপনার পিটিশনটা কই? হ্যাঁ দেখাচ্ছি। A4.
34 to the dispute, right? Is there a stay of operation of the award?
My lord,
The lordship, my lord, upon payment of the security. Security was only for 56 lakhs, the principal amount.
So they have deposited that?
Yes,
my lord, the
Lying with the
yes,
registrar.
lined with the registrar general, my lord, in a approved security and interest bearing account.
Very well.
order dated 22/7.
Yes. What were you showing us?
My lord, I was, my lord, referring to, my lord, I'm led by Mr. Banerjee.
Yes.
Claim 4 and 8. Milord, these are the milord, the two claims are milord, the question before your lordship, because the learned arbitrator, milord, while milord dealing with the claim 4, if your lordship kindly see, there is no reason at all.
Page 190 তে চলে যান।
Page 119, lordship kindly see.
Where's the impugned order, Mr. Banerjee?
That page, দেখো তো
আমি বলে দিচ্ছি ইমপিউন অর্ডার is at page 91.
91 91 ঠিক তো
হুম
আমরা কোন জায়গাটাতে কোন জায়গাটায়
না এখানেতে ইমপিউন অর্ডারে যাওয়ার আগে ইমপিউন অর্ডারে সবই ক্লেম দুটো ক্লেম আপলোড করেছে
না আপলোড করলো মানে গ্রাউন্ড কি দিবে
এই
ক্লেম নাম্বার 9 ক্লেম নাম্বার 4 and 8 টা কি বলবো সেটা দেখো কোন জায়গাটাতে আছে
105 থেকে এই টাকাটা 63 লাখ টাকাটা থেকে 32 লাখ টাকা দিল
দিল মানে
মানে এইটা অ্যালাউ করলো আরবিট্রেটর
63 লাখ টাকা 19 থেকে
ক্লেম
63
ছিল আর এইটা আরবিট্রেটর দিল এই জায়গাটাতে ক্লেম ফোরটা
বলছি তো Blood, if you lordship kindly blood turn to page 105. Judgment
Allow Mr. Banerjee, take your seat.
My-
We'll read the.
for your lordship kindly blood.
Mr. Banerjee, come back at 2 p.m.
Well, before your lordship's rising, with the leave of Mrs. Umran, I am mentioning tomorrow single bench, one addition, new government. Let it appear tomorrow. I'm grateful, man.
We'll come back. We have read the impugned order. We have read the arbitral award. Now we'll hear you. If necessary, we'll hear you. And We'll pass the order.
Sir, no use pressing, no liberty.
Grateful,
pressing.
grateful,
No,
grateful.
no,
No, no, no.
mention.
Ragna. My lordship only will point this out that already an arbitrator has been appointed. This is the appointment of the arbitrator.
Yes, that's all right, but no liberty is
No,
required.
no, I don't want a liberty. Lordship will say since there is arbitration, so he's withdrawing the
Say
matter.
anything
No, no.
since you want
Why?
to withdraw, you withdraw.
No, why am I withdrawing? I want to
Full
pull out.
withdrawal.
That submission I will record.
This is your application only section 11.
দেখি নিয়ে নিন। ফাইল লাগবে না, শুনুন, আপনি শুনুন। Mentioning notice টা দিন।
দাঁড়াও না, সব দিয়েছি আমি। অর্ডার কপি দিয়ে দিয়েছি আমি।
I want to withdraw of
Oh, yeah.
this matter has been listed upon the same being mentioned on August 20, 2025 by your good name, sir?
Debashish Mitra.
Mr. Devashish Mitra. It was submitted that the matter needs to be withdrawn, and as such, the same should be taken up out of that full stop paragraph. Paragraph 9, the piece of mentioning It is submitted that a notice of mentioning dated August 19, 2025 has already been served. Who have you served?
Podarashil.
Podarashil, this is for him. He was called in. Lordship will see this. This is the email which I sent. Email appearing for. Lordship will see the email. Learned advocate appearing. Too late. File less. No, keep this with you. Don't do like that. I don't like.
Sir, respondent number 1, Union of India.
Don't want anything.
Just want on the order.
Of the two prana as well as the mentioning slip along with a printout of the email is taken on record. Full stop. Paragraph. Mr. Mitra, assisted by Mr. Sumit Mishra. You are the advocate.
I have Mr. Malik also with me.
I have a letter of Mr. Mishra only, and he is the advocate on record. I'm recording by Mr. Sumit Mishra and the advocate on record for the petitioner. One petitioner or many?
One petitioner. The company.
Submit that since Coal India Limited has already invoked the arbitration clause.
Yes. And I've given the and appointed
and an arbitrator has been appointed pursuant thereto. The writ petitioner seeks to withdraw the present writ petition.
and take all the upon of the arbitrator, if so advised.
In order to avail appropriate remedies. Full stop. Since it has been submitted that the writ petitioner seeks to withdraw the petition, WPA 4455 of 2025 is dismissed as withdrawn. Full stop. There shall be no orders to posts.
Only one thing,
Respondents are represented.
my lord, Lordship, one thing, it shouldn't come as res judicata, all point kept open before the arbitrator.
Withdrawing what res
No, but
judicata?
what I'm saying, it shall be come as res judicata, my lord.
I will not make that observation here. Sir.
Grateful, Lord. Grateful. That's okay. Grateful. अरे भाई रुकना इसमें क्या
আছে আমার দিতে হবে আমার দেওয়া হয়নি এখন
ডাইনার টেকনোলজিতে বার করেছো? হ্যাঁ? আচ্ছা, কন্টেম্পট তা মনে নেই, কিন্তু 34 এর উপর।
Mr. Sen.
Yes.
One slight problem is in claim number 4.
Yes.
All is very well. There's a variation clause. Your client conceded. Your client had claimed beyond 10% of extra work,
Yes.
but then conceded beyond 25%. But this figure of 33,52,000, suddenly it is plucked from the sky.
No, but your lordship will kindly see first word before that, page 196, last part. So in this case, after it is written, moreover, advocate for the claimant agreed in the 15th sitting that reasonable variation will be plus minus 25%.
That's right.
Yes. Then, so in this case, claimant is allowed the rates for extra work beyond 25% of the scheduled quantity to be paid as per schedule of rates for 91-92 for those items whose quantities have been exceeded. So it is based on the extra rate of extra work beyond 25% as per the schedule of rates of 91-92.
How much is that?
But that he has said in view of our difference of rates between the rates as per schedule of rates for year 91-92 and original rates as per tender schedule, whose appointment have been exceeded 20 are taken into consideration for determining the claim amount. So based on this, he has come to 32 lakhs, 33 lakhs.
What is the quantity of extra work?
Well, that is also that has already been given in my statement of claim. Only difference was the rate. It is not the quantum of work, extra work was not disputed. Not the quantum of the factum of extra work, nothing was disputed. So what the arbitrator felt that since now he has considered that beyond 25% it is admissible. So if it is beyond 25%, then your claim amount of 62 lakhs cannot be granted. So therefore, rate of extra work beyond 25%, taking into consideration 91-92 schedule of rate. So this is what this is the ground behind reducing it to 33 lakhs.
Anywhere in the award, this extra work has been mentioned. How much extra work?
Well, that is in the statement of claim, because I have made a computation. If your lordship kindly sees the first part.
How do we know that your computation is right, or he is saying that your computation is right?
No, that is from the statement of defense. That exercise is worked out at the stage of trial. Suppose I say that for X item, I have done this amount of extra work, and that is as per the measurement recorded. Now, it is the question which was arising is
am I entitled to the extra work? First, their objection was everything is included, you are not entitled to extra work. The arbitrator, relying upon the Supreme Court, felt no, in the principle of Section 70 of the Contract Act, beyond a certain limit, extra work has to be given.
I mean, variation clause can't give you an unlimited power.
Unlimited. So the variation up to plus minus 10%, it is taken into the rate. So now there is the fact that I have accepted, yes, after 25%, I will be charging the extra work. So there has been a requirement of fresh analysis and calculation, which has come down to 35 lakhs or 33 lakhs, whatever is the amount. Here, my lord, that exercise cannot be done at the 34th stage, whether the quantum was right or wrong, because that was already done in the trial stage before the arbitrator. You did not take that point. Your point was claim is not admissible at all. It is covered by the variation clause. Kindly, if I may just show your lordship the objection.
No, we are looking at the award. We are looking at the award.
Yes, I am also looking at the award. Claim number 4 at page 194. If your lordship kindly comes to claim number 4 at 194, where claim number 4 has been discussed. This is a, kindly see, it is for additional amount payable on account of excess additional work executed beyond 10% of the estimated quantity of works. And as per instruction of engineer in charge, 63 lakhs was my original claim. Claim is explained in 23.3 of the statement of fact. So the details of 63 lakhs is there. Then kindly see, Vinod, I am not reading that part, Vinod. Kindly come to the middle of the second paragraph, which says that in the instant case, claimant quoted average percentage by considering tender quantity with a possible variation plus minus 10%. In the instant case, against accepted tender amount of such and such, value of work as per the final bill prepared by the respondent was 2 crore 16. This is an admitted position. Kindly note, value of work as per final bill prepared by the respondent. There is no factual dispute with regard to this. Execution of the extra amount. So, excess work beyond accepted tender amount was 73.28%. These are matters beyond the pale of challenge. Your bill. So, therefore, now the question is, if there is a 73% excess work already done, should I be restricted to plus minus 10% as per the variation clause? But the claimant has considered that I am not going to charge 73% over and above the plus 10%. I will only charge over and above 25%. That means around excess 50% I am entitled. This is, my lord, thereafter kindly see. I think this is actually the crux. Final bill value is an admitted one. Then, my lord, kindly see, if your lordship comes to towards the bottom of the page, claimant further submitted. This is my submission regarding the quantum, how I have arrived at 63 lakhs. Claimant further submitted that, well, I'm sorry, my lord, if I can continue reading after that, the lordship will find the I will kindly read last paragraph of 195, which is the respondent's case. Respondent dealt with this claim in the 39th sitting and submitted as under. This is the scope of their defense. said alleged claim of the the finding starts thereafter from the evidence on record.
What's it do with arbitration?
আইনাটা বার করে ওখানে একটা আছে sufficiency of reasons cannot be gone into প্যারাগ্রাফটা বার করে আমাকে পাঠিয়ে দাও বার করে দিচ্ছি পাঠাও Done. দেখো এখানে adequacy of reasons বলে আছে একটুখানি হ্যাঁ লিখে রাখো একটা 37 অ্যাপিলের একটা জাজমেন্ট দিয়েছিলেন হ্যাঁ হ্যাঁ ওইটা দেখুন হুম।
Please, sure, Mr. Sen.
But I come to page 196, the reasoning part of the claim number 4. Kindly see what the arbitrator has said from the evidence on record, that part.
Yes.
I find that this claim number 4 was explained by the claimant in paragraph 23.3 of the statement of claim. Respondent dealt with the said paragraph 23.3 in paragraph 34 of the counter statement of fact, in which respondent dealt with paragraph 23.7 of the statement of there was absolutely no denial of the fact stated by the claimant in paragraph 23.3 of the counter statement. That means execution of extra work to the extent of the final bill value, which is amounting to more than 78%, as noticed by the arbitrator, is not in dispute. It is now only a question which was raised is whether this claim is admissible by virtue of the variation clause.
You also claimed a higher rate for this extra work, isn't that right?
No, my lord, I have claimed as per the schedule of rates 91-92.
That is higher than the tender rate.
Because
No, whatever it
yes,
is, yes.
and here's the reason is that when the work was actually done, at that time, this schedule of rates of 91, 92 were in vogue. So because this is a claim of a quasi-contract.
Was the tender rate lower than 91, 92?
Yes, because my lord, he has written here, claimed difference in rates between tender rate and the rates provided in the schedule of rates for 91, 92.
Tender rate to যেটা quote করেছে।
Because my principle is that I have done the work beyond the contract. It is an extra work outside the contract and done at a point of time when the contract could have been otherwise over.
We have no problem there. If only he made it a little clearer.
I'll tell you, my lord, to assist your lordship there, my lord, there is a judgment of Dyna Technologies which says comments on the adequacy or sufficiency of the reasons also. My lord, if your lordship, I will give the judgment, but permit me to read out.
China has not been adversely commented upon in the latest judgment. I think it has been.
No, that is on the aspect of it was being remanded once again under 34(4), whether it could have been done. Supreme Court had said that since substantial time had elapsed, no purpose would be subserved in again remanding the matter to the arbitrator on the point of reasons, and therefore an ad hoc amount was granted by the Supreme Court. But on the question of reasons, the Supreme Court has specifically commented here that the reason may not be to the liking of a court, but the test is whether the reason is completely unintelligible. Then the court has no option. But here, if I try to assist your lordship, if your lordship kindly sees thereafter, there is no dispute. May I just permit me to carry on there? There is no dispute regarding quantity of work done by the claimant. It is a fact that all excess work executed by the claimant has been accounted for in the final bill at the tender rate. Same is also admitted by the claimant, but claimant claimed extra amount for excess quantity beyond 10% of the tender quantity on the basis of respondent schedule of rate for 91-92, which was in force during the execution of the work. So everything he has taken into consideration. In other words, claimant has claimed difference in rates between tender rates and the rates provided in schedule of rates for 91-92. Ordinarily, I would have been entitled to entire 62 lakhs. Because on fact, no dispute has been found. It is also not found that I have not taken the correct rate. It is not found that there is no extra work. I have considered that very well. After additional over 25%, I will raise my claim. So I thought it was for my client to challenge the award on this score, why it was reduced from 62 lakhs. But I cannot, because I have made a concession before the arbitrator, which is recorded. So the only point which was raised by them, that variation clause covers this, and that has been dealt with by the arbitrator.
Also read paragraph 42 of that judgment.
No, I will come to that judgment, Manoj. That judgment is on the account of loss of profit and loss of overheads. That, Manoj, is a completely distinguishable judgment. Now, if your lordship comes to thereafter, Manoj, if your lordship sees the second last paragraph of 196.
So, one second. So, will you say that it is decipherable from the award that the arbitrator has applied the 91-92 schedule rate to the extra work beyond 25%?
Yes.
That is how this figure is arrived.
And that is very well understood from the language. No one can say that there are some gray areas, that why did he take more than 25%? That was on my concession. Otherwise, I would have been entitled to more. Unless you find a flaw in the factum of execution of the extra work. And that he has relied upon their final bill value. Final bill value has been paid. They can't go beyond the final bill value. Just one line, if your lordship just comes to 197 top. Just what your lordship said is also reflected here. It is not that your lordship has to make a deduction. Your lordship kindly reads this part. So in this case, at the top, claimant is allowed rates for extra work beyond 25% of the scheduled quantity to be paid as per schedule of rates for the year 91-92. For those items, kindly see, for those items whose quantities have exceeded. It's not a blanket. Or it is not like that you have claimed 62, I am reducing it to 35. And he has said why schedule of rates for 91-92 will also be applicable. That also, my lord, they have not disputed. That is not the schedule of rate which is applicable here. Some other rate was in vogue at that point of time. That is also a question of fact which is decided.
All right.
Now, just my learned friend's judgment.
Yes.
Kindly have a look at the judgment, but
that judgment has referred by my learned friend. Paragraph 42 I am relying upon. His judgment.
Yes. Kindly come.
Diana. Yes. Paragraph 42 I am relying upon.
I am relying on the other paragraphs also.
That is
because this is a case of an absolute unreasoned ineligible award. Diana. There it is said that what is the nature of the reasons which is to be provided.
No, just a portion. Just a portion for you. Very clear.
Kindly come to paragraph 35 of the judgment once.
Yes.
Just kindly come to paragraph 35 once of Diana. The mandate on the mandate on the 31(3) of the Act is to have reasoning which is intelligible and adequate and which can in appropriate cases be even implied by the courts from a fair reading of the award and the documents referred to thereunder if the need be. The aforesaid provision does not require an elaborate judgment to be passed by the arbitrators having regard to the speedy resolution of dispute. When we consider the requirement of a reasoned order, the characteristics of a reasoned order can be fathomed. They are proper, intelligible, and adequate. If the reasonings in the order are improper, they reveal a flaw in the decision-making process. If the challenge to an award is based on impropriety or perversity in the reasoning, then it can be challenged strictly on the grounds provided under 34 of the Arbitration Act. If the challenge to an award is based on the ground that the same is unintelligible, the same would be equivalent of providing no reasons at all. This is not a case of no reasons at all. My lord, thereafter, my lord, coming to the last aspect concerning the challenge on adequacy of reasons. The court, while exercising jurisdiction on the 34, has to adjudicate the validity of such an award based on the degree of particularity of reasoning required, having regard to the nature of issues falling for consideration.
5 sessions. এটার থেকে বেশি হ্যাঁ 5 এটা 3
Thereafter, my lord, the very next line, your lordship will kindly see. The degree of particularity cannot be stated in a precise manner, as the same would depend on the complexity of the issue.
এটা reasonable কথা বলছে you don't expect a judgment from arbitrator which you may expect from a high court judge or even if it can be implied in certain cases from the records. Cover আজকে টাইম পাবি না হয়তো কালকে বসে এখানে বসে দিয়ে দেয় yes
Next line, my lord, even if the court comes to a conclusion that there were gaps in the reasoning for the conclusions reached by the tribunal, the court needs to have regard to the documents submitted by the parties and contentions raised before the tribunal, so that awards with inadequate reasons are not set aside in casual and cavalier manner. On the other hand, ordinary until have to be set aside subject to party autonomy, such and such. Therefore, courts are required to be careful while distinguishing between inadequacy of reasons in an award and unintelligible award. This is not an unintelligible award at all, my lord. The greatest of respect, my lord. And my lord, if I come to the judgment of my learned friend once, my lord, your lordship sees that is 24 to SCC. 42 chahiye, please put. My learned friend insists that I should show 42. Very well. Let me just.
42 of Dinah?
Yes.
We have read it. We have read it.
Paragraph 8 of this judgment has been placed, Bartley boy. Yes, and 42 to 47. 44. Achha. Kindly come to paragraph 8. Yes. The second patent error relates to computation and award of 10% of the contract value towards loss of overheads and another 10% towards loss of profitability. Two amounts have been quantified at 78,68,000 each. Thus, 1,57,00,000 has been awarded and held as payable by HPCL to be. The award is deficit. So what does it mean? I have claimed loss of overhead and loss of profit, and I give an amount. I have just, in the statement of claim, I have given an amount. Lordship will notice in the later part of the judgment, the court has said that a loss of profit, you will have to first prove two things. Loss of profit is not a damage which is ordinarily accruing. You will have to show that how you have suffered the loss of profit. There were other projects in hand which you could not do. Those are the details which you have mentioned. Quantification part comes later. First is your justification for claiming this damage. You have suffered actual loss. Then you can claim the loss of profit. But here the arbitrator had simpliciter given this figure. That is the difference. I have given 62 lakhs here on the basis of the final bill value showing more than 78% of the work has been done. And the figure has been computed on the basis of schedule of rates of 91-92, justifying that when the work was being done, those rates of the respondent were in vogue. Now, in this context, kindly read paragraph 44, which my learned friend has placed. (44) refers to associated builders. I don't think that's a proposition of law under 34, where this is also elaborately explained question of public policy specifically under the head fundamental policy. It was firstly held when jury demands that to be reasonable and objective, anything arbitrary and then my lord 45 is Western Gecko. Decision would be irrational and perverse. I do not know, my lord, how this paragraph helps my learned friend.
Yes, these may not.
This may not apply, but I will show you that part of the judgment where the court says, in the context of a claim of loss of profit, what are the ingredients that have to be established?
Yes, we remember that, Mr.
So in that SRMB matter, I think Mr. Mitro was placing that. There we had shown your lordship, loss of profit stands on a different footing altogether. We can't simply say, as was done in the case of 80 Bridgepal, the contract value is this much. So 10% of the contract value is my estimation of loss of profit.
There 15% was about it.
15% more, but value comes later. First is my entitlement. Suppose I did not have any other work in hand at that point of time. So even if the work was, this particular contract was extended, what loss did I suffer? There was no work in my hand. So I had to prove that there were available works which I could not do because I was engaged in this work still. Those are the elements, my lord, which have been spoken of in Bartley Boy and said that the arbitrator's award merely takes the amount without the justification of the damages being actually suffered. So, my lord, I think this judgment will be distinguishable, and I rely on 197 first paragraph to say that this is the assimilation of the reason. These are my submissions.
দিবি তো এটা শুরু করতে পারিস 3টে অবধি দিয়ে আমরা কালকে করতে যা তোর সুবিধা না শেষ হলো না ঠিক আছে একবার তুই একবার দেখেও আসতে পারবি টুমরো ফর অর্ডার্স লিখে নাও We have heard learned counsel for the parties.
Hearing concluded or not?
Yes, yes. We have heard learned counsel for the
He
parties.
may not be there, my junior will be there.
Yes, yes. He will be deemed to be president.
I will try to, my lord.
Which part of the world you will be in? Rajarhat.
But no. Non Calcutta. Otherwise, I would.
Madam, at length. Stop. Paragraph lists the matter under the heading for orders. Kalke. Marked 10:30. Marked 10:30 a.m. Marked 10:30 a.m.
Obliged.
What are the hearing conclusions? Similar 197, your lordship kindly consider that the statement of the parties have been discussed, but thereafter therefore pass the award.
All right.
Your lordship kindly consider that part. I'm giving obliged. চলো আমি লোক আছে
Lordship, we couldn't find out the address of the party. Your Lordship has directed to serve the copy upon the advocate on behalf of the respondent number 2, but we couldn't find out the address of the advocate who is appearing on behalf of the respondent number 2. So we directly served the copy upon the party, and the service has not yet been completed. Lordship, kindly give accommodation for this week only. Keep it in any day of the next week, kindly.
Service is not complete.
No, Lordship, service has not yet been completed.
5th August, we had passed the order. When shall we keep it?
Uh,
When should we keep it? Who are you for?
For NSC, Your Lordship. Lordship, kindly keep it any day next week.
NSC?
Yes, Your Lordship, the respondent number 1 is the arbitrator who was appointed by NSC.
How long? How long should we adjourn it for?
Any day of the upcoming week, Lordship.
Upcoming?
Upcoming week, any day.
Next Thursday?
Next Thursday. Okay. Okay, grateful, Lordship.
Learned advocate for the respondent, for the appellant, says that service on the respondent number 2 is not yet complete. Paragraph as requested, comma, list this matter once again on Shamni Bushpatibar Tarik dao 28.
Grateful. Good.
I appear on behalf of the respondent, Your Lordship.
I appear on behalf of the petitioner, appellant. Paper book number?
Lordship, this matter was sent to mediation.
And for
Yes, was sent
mediation?
to mediation, Your Lordship. It has failed. We have come up with Your Lordship. It is my learned friend's 37 application.
Justice Sen had sent.
Yes, Your Lordship.
Report ki ektai দেয় নাকি?
Award passed.
I like to submit one supplementary paper book.
Final report.
আমরা হয়নি এটা।
প্রথম award was passed in whose favor?
My learned friend's favor.
That was set aside in 34. You want to file a supplementary paper?
Yes, my lord.
What is
Three
that?
documents are missing in the previous paper book. One is a part of a letter, second is the completion certificate, and third is the agreement.
May I just indicate, Your Lordship, what?
Otherwise, paper book has been filed.
Yes,
my lord. The supplementary.
Supplementary paper book, take it on record. You give him a copy.
I have been served a copy. There is
Yeah.
no issue with that.
So when will you argue the appeal?
Let them start.
I can start.
I'll come back
Actually, I
only.
can start.
You can start for 12 minutes because 3 o'clock there is a matter fixed.
Let him start, Your Lordship. I'll also have a
Start.
idea.
Show us the impugned order first. Hey, Abhijit, आगे लिखो. Final report of the learned mediator is filed in court today. Stop. Let the same be kept with the records. Paragraph from the report, we find that the mediation between the parties has failed. Stop. Hence, the appeal has to be heard. Paragraph. Learned advocate for the appellant begins his argument but does not conclude. Paragraph. Lists the matter আবার মঙ্গলবার রেখে দাও আমি অর্ডারটা আগেই দিয়ে দিলাম বুঝতে পেরেছো এটাই হবে তো
Lordship is keeping it on?
Yes.
Lordship is kept it on?
Tuesday?
Lordship.
No, you start.
Yeah, no, I am starting.
Yes.
My lord, please.
Where is the impugned order?
It is in page number 330, volume 2 of the paper book. Oh, impugned order is at page 416.
Paper book volume 2.
My lord, may I briefly state what is the work all about?
Yes.
My lord, it's a contract of Science City, electrical contract for Science City in the year 1997. I was awarded 2 contracts to deploy all the electrical connections. My work is related to the construction of other civil works.
You also did the electrical work for that dinosaur that is there?
Yes.
I see. Dinosaur.
In 1997, I was in school. From school, we went to the Science City to see all these things.
Yes.
So it is nearly 30 years. Our claims are very. First, I express the work. The electrical connections, as you know, my lord, everybody knows that after completion of the structural work or civil work, that needs to be done. So it's a related work. Some parts when some ducts need to be installed, means some pipelines that needs to be installed during the civil work, that is in the roofs. Other than that, all the electrical connection has to be completed after the civil work is completed. So it's related. The work is for initially for 6 months. Due to the delay in completion of the civil work, the electrical work got extended for 4 years. My claim is for escalation, that is included in the contract clause 30, and for prolongation of work. There are some instruction for new items. There are some modification of items. Those are treated as extra work, and my claim is for that. Then I am claim allowed in my, that is the loss of profit, and 3 claims related to. One is the extension of bank guarantee. Due to prolongation of work, I have to pay the extra charges to the bank. Another claim is I have submitted, they have deducted sale tax from my bills, but they have not issued certificate. During those days, the employer needs to issue certificates in a specific time so that we can file the return. That was not done. Those are our claims allowed by the arbitrator.
Arbitrator appointed by the parties?
By the party, by the employer, Science City.
Science City.
Yes.
In the arbitration clause, they had the power to nominate.
Yes, it's 1996. During that time, it was in the arbitration clause.
Okay, whom did they appoint? Whom did they appoint? Who was the arbitrator?
Arbitrator is.
What was the award amount?
Award amount is very less, my lord.
9 lakhs and 9 lakhs, approximately 18 lakhs.
18 lakhs odd.
Very well. Yes, then tell us.
In section 34, in arbitrator held that the delay was contributable 20% to the employer, to me, and 80% to the employer. And there is a specific letter from the employer that the price escalation will not be implemented for 4 months. So out of 4 years, by their letter, it proves that 4 months price escalation clause should not be operated. But other than that, the labor price escalation and the material price escalation is incorporated in the contract in clause 30. So it is absolute. There is no case that the arbitrator has traveled beyond the contract and awarded some.
Before which court the award was challenged?
Alipur
court.
ADJ Alipur.
Yes.
So, my lord, I have already filed a short notes on short notes in this matter in the previous date. So, so I can start with that first, that the claim number 1, which is the escalation claim, is incorporated in the contract. That is under clause 30. Kindly, my lord.
উনি কি নোট ফাইল করেছেন বলছেন?
I have given elaborated point by point factual notes by which my lords can understand. Duto copies.
This is the one.
Yes, my lord. First page is because it's a huge document. First page I have placed what is the case. Just now I have expressed, my lord, that how the contract goes on. Means the electrical work, it only be done after the completion of the civil work. So that is been elaborated in the first page. My lord, please come to the supplementary paper book.
Hey, in the event your lordship is relying on the note, in the event your lordship is relying on the note, I have to indicate that I do not know what my learned friend is relying on. The note was not given to me, your lordship.
I will
No, I do not know what.
Give him a copy of the note. It's factual.
Only factual brief.
That's all. I am not aware of as to what the note contains. That is why I had to indicate. Page number
বলে দেবো পেজ নাম্বার আমি তোমার দিয়েই দিচ্ছি তোমার পেজ নাম্বারটা বলে Firstly, my lord, I like to place page number 3 of the supplementary paper book, the completion certificate. My lord, this is issued by the Science City to my client. This is to certify that MS Raiko Engineering Syndicate, such and such address, has completed the job of electrical illumination and small power distribution for both internal and external at the premises of the Science City, Calcutta, under National Council of Science Museum, Government of India in phase 1 and phase 2. Phase 1 involves electrical installation for internal illumination in main auditorium, mini auditorium, gate complex, seminar hall and other associated areas, including electrical jobs for computers. Phase 2 includes electrical installation in Space Odyssey and Dynamation building at Science City. The cost of project was for rupees 41,93,000. The performance of these two paragraphs are important. The performance of the installations are found to be to our best satisfaction, and the workmanship, quality and standard of works by the contractor are quite satisfactory. We have no hesitation to recommend that MS Raiko Engineering Syndicate is a reliable, dependable, technically expert electrical contractor under the able leadership of Mr. Amitabh Rai, managing partner of the company. So this was the certificate issued after completion of the work, that is after the total duration of 4 years. In this completion certificate, it clearly reflects that the employer has absolutely no problem with our conduct during the currency of the contract. Even they are proposing and recommending others that we are very reliable and expert in installation of electrical works. So the basic principle here like to indicate that when a completion certificate clearly appraise my conduct and performance, the delay attributable, which is held by the learned judge in section 34, the delay attributable or any other penal clauses which are not imposed upon me is not a bar to uphold the award.
So you did the work when? Which year the contract was awarded?
1997. Completed on 1999. Final measurement done on 2000. Payment accordingly. So 4 years. My claims are absolutely limited, sir. Please, requesting you to come to the
In 1999, which month you completed your work?
1 minute, sir. Completion certificate says
No, which month you completed the work?
completion certificate as a 6 January 1999 issued.
Cool. Yes. Sir, what is your full good name?
Orindam Shamanto.
Mr. Shamanto, we have to take up a fixed matter.
Yeah.
Huh? So it'll run in the list whenever. Lekho. Oi, likhe to dicho.
One prayer, Your
Or next Tuesday.
Yes, Your Lordship, one prayer that a note be handed over, Your Lordship. What's in the prayer? Because
It is really not a note, you know. It is in the form of.
if it is being placed, I would have reference.
Yeah, you give him a copy.
Grateful.
After how long are you visiting the city of joy?
Been longer than I would like it to be. It's been about, I think, a year. Been a while.
Okay, all right.
Always a pleasure.
Exide.
Yes.
Exide. Amaron.
আমি তো বলছি যে আমাকে ফি না দিয়ে আমার বিয়ার আগে ফি দেওয়া ফর ক্যারিং দিস
Mr. Luthra, yours was Maudlin, no?
Not mine was not. I was at Fitzwilliam.
Fitzwilliam. Churchill is on your other side.
She was on my other side, just behind. and
Close neighbors.
Close neighbors. Churchill and St. Edmunds is right next door. New Hall and St. Edmunds.
Yes.
Now, of course, it's called Edmund Murray. What is it called? Eddie Edmund Murray.
Right.
Now changed.
No, that's
St. Edmunds.
No, the one behind us. Behind Fitzwilliam.
Lucy Cavendish.
Lucy Cavendish.
Lucy Cavendish.
No, that's used to be called New Hall in my time.
Right.
No, Lucy Cavendish was a new hall.
No, sir.
No.
Yes, New Hall was just next to Fitz.
Yeah, so there's one new hall, totally different. Lucy Cavendish is totally different.
This then that's called. Anyway, I'll get the name in a moment. Lot has changed.
So my daughter went to Lucy Cavendish.
This was the one. New Hall.
No.
It's been a while, though. I do go back once in a while.
Yep.
It's always a pleasure to be back.
Yes. Thank you. Okay. So it's your appeal.
Well, this is an appeal from an order of the learned trial judge dated 25th July 2025.
Mr. Mitra, we have both gone through the order, so you can take it that we have read the order.
Very good.
Now you can make your submission.
Yes. Well,
And for the benefit of your learned friends, can we release them?
Yes.
Will you keep us occupied till
I think we should.
4:15 because we are going to rise at 4:15 today.
No, it'll take that much time to.
Okay, then released. Kore dao, chhede dao.
Well, I will request your lordship, but this is a case of passing off. Nothing to do with infringement of trademark. It's a passing off case. And my lord, your lordship knows, my lord, in a case for passing off, my lord, three things, my lord. One has to, first is, my lord, deception, confusion. That is for the purpose of establishing confusion, one will have to prove first the goodwill, the mark, whether it is a mark with name, or it is, my lord, color or whatever it is, one will have to acquire the goodwill. Meaning thereby that the mark which is sought to be adverted to has got to be associated with the plaintiff. That's one. Second, my lord, second ingredient is misrepresentation. In other words, there is no, so to say, willfulness is involved. If, my lord, even unwittingly, if there is a misrepresentation, meaning thereby, so far as the petitioner is concerned, so far as the respondent is concerned, respondent's goods, my lord, is likely to lead the public to believe that the goods offered by the respondent is the goods of the petitioner. Then, my lord, the misrepresentation is proved. And third element is damage. These three things together constitute, my lord, the tort of passing off. Now, in the facts of the instant case, I would request your lordship first, my lord, to take the judgment and page 8. I am drawing your lordship's attention to this page because this page, my lord, contains, my lord, in paragraph 11, a comparison of the rival products. My lord, both are manufacturers of automotive battery. My lord, my learned friend's client is manufacturing Excite battery, and we are manufacturing, my lord, Elito battery. The issue is as to whether, if your lordship sees these two side by side, whether it can lead to any confusion in the mind of the public who are buying these things. The 2 points we made with regard to this, first of all, we said that one cannot have any monopoly on color. That was the first issue point that we made, and that was accepted by the learned judge. So if one is not entitled to have monopoly on color, one will have to show that by reason of the color of the trade dress, it has acquired a secondary meaning, by reason of which, my lord, the color is being associated with the goods manufactured by the petitioner. In other words, one will have to say that when I think of red battery, I think of Excite and no other battery. This is the first. Second point we made was this, that when you see these two side by side, is there any possibility of confusion? Because, my lord, we relied upon that line of judgments of the Supreme Court and also with the foreign courts, that if the defendant can show there is some added matter to the, my lord, the product, which makes a distinction between the two, then, my lord, the defendant escapes liability. So our submission was this, that when these batteries, two batteries are in the market, they are on the rack. First is that the names of the batteries are written in bold letters. So one has got no opportunity or there is no scope of getting confused. One is written Excite battery and the other is Elito battery. Number one.
Can I put the boxes here to show?
Sorry, yeah, the boxes are there. But we are showing your lordship the boxes. Well, these are the boxes, and the batteries are there. If your lordship sees, you better be careful.
They got me for this purpose. And they needed somebody to pick up the batteries.
Yes, well, we needed a stronger man than me.
Nobody can be stronger than you.
They are breaking our batteries.
No, they used to have water in them. If you, my lord recalls, initially they used to be white.
Yeah, yeah.
Distilled water. Now they're sealed units, so they're safe.
I can do the same to yours.
You already.
So long as you don't break each other's head, it's all right.
As long as you don't lift the batteries, go leave it to
No, no,
Gopal
I'm not.
and-
I'm not.
and Mr.
I have left it to a stronger man than me, myself. My lord,
Obviously, it would be the right.
Mr. Metro would be the right.
my lord, our submission was that this, first of all, in our battery, Elito is written boldly. Secondly, my lord, the manufacturer's name is also on our battery, which is not on their battery. It is, my lord, it is written Hamara Raja.
Here, sir, here. It is here, sir, here. This part, both sides, everywhere. This here is here, Amara.
The name of the manufacturer is also written.
It's on the box or on the battery?
On the box and also battery. And on the battery. Your lordship can see this particular photo. Perhaps your lordship will be able to see there is a black square on Elito battery at the bottom.
Yes.
There, my lord, the name of the manufacturer.
Amara Raja.
Yes. Amara Raja. But your lordship sees, my lord, the name of the respondent is, my lord, Amara Raja, or rather, when I respond, I should say appellant, Amara Raja Energy and Mobility Limited.
The colors are also different color. The photo package is going 1499 volume 10. This entire truck driver picture. The colors are also distinguished. Pantone shades are different. The lighter shades.
Well, our submission had been that you look at these two. First of all, remember the persons who go to buy these batteries. This is not, my lord, lollipops or a bar of chocolate. One goes there, one is more than 4,000 rupees, the other is more than 3,000 rupees. So look at the price. It is not something which is to be purchased across the counter. A person who goes there is fully conscious as to what he is going to buy.
It's already fitted to the car.
For two reasons. As my learned friend correctly points out, when I buy a car, I buy, say, Toyota. Along with the car comes my battery. It may be, my lord, Excite battery, it may be Amara Raja, maybe Live Guard. There are three different types of batteries there. Now, so I don't buy the battery, I buy the car along with the battery. Now, if that battery, my lord, is to be replaced, then I go to the shop and buy the same battery. Either that, or if I am not happy with the battery which had been put in my car, then I go to the shop and say, I want to buy a good battery. What do I do? Either I take the advice from my own motor mechanic or whoever it is and go to the shop and say that give me this battery, or I ask the battery owner, the person who is sitting in the shop, expecting that he is an expert in that. I would ask him that my battery was this, I want to replace it, which battery I should take. Now the point is this:
in the company where the vehicle is serviced, they have their own products.
or if the vehicle is to be serviced at a particular place, then that particular shop, the owner, he will advise me. What I wanted to submit to the court is this: that this is one such material, one such object which are purchased not across the counter. And my lord, our submission was, it is not an object or a material which is purchased by a person of average intelligence and imperfect recollection. So that is the test, my lord. This is not one buys, my lord, just off the cuff. My lord, upon consideration, upon thoughtful consideration of, because he has to spend a good amount of money for that. So the price is important. The nature of the goods is important. The person who is advising you to buy the goods, that is also important. So keeping all this in mind, this is not something which, my lord, by which, my lord, a person of average intelligence and imperfect recollection will be misled into buying this. This was the second point. Third point we said, and this is with great emphasis I said so, I say without any fear of contradiction, I said that you go into the shop, you don't go and say that I want to buy a red battery. You say that I want to buy Exide. You go and say I want to buy Amara Raja. You go and say that I want to buy Live Guard. This is of utmost importance. And when you do that, you do not shut your eyes and pick up the battery. You see what is written over there. My lord, if I may say so with great respect, my lord, a person who is going to buy a battery and wants to buy Exide battery, he will not, my lord, go and say that I want to buy a red battery, therefore give me any red battery. And therefore there is a possibility of confusion. My lord, if I may just quote, and in fact I quoted it repeatedly before the learned trial judge, the famous statement of Lord Halsbury, Lord Chancellor, in the case of Schweppes versus Gibbons. He said this: I would have thought if you looked at the two bottles together, it was a case of bottles together, no human being could have mistaken the one for the other.
Bottle of what?
It was bottle of
Schweppes, tonic water, my lord. Tonic water at a bar. Yes, my lord, at a pub.
Nothing stronger than that. And thankfully, my lord, tonic water. Not after two pegs.
Even after 2 pegs. But even there, the customer will be sophisticated as it is here. The sophistication of the customer is what we are concerned.
Yeah.
So, my lord, this is and he further said in that judgment, to apply the proposition to this case appears to me to be a little short of ridiculous. And this statements, my lord, I went on. These are Lord Halsbury's statement, Lord Chancellor, in the House of Lords. And my lord, I did not have, I think, in the Privy Council. And my lord, I went on repeating this. I said that any person going into the shop, after all, this is a case of what? This is not a case of infringement of trademark. This is a case of passing off. I said that this is my submission was this, that
see, ultimately it boils down to possibility of deception, confusion.
Absolutely.
That's it.
This concept of deception, my lord, unfortunately, what happened was this: the court went on the basis of reputation and goodwill and did not cross that particular barrier and went into the question of misrepresentation. Because in order to constitute this particular tort, one has to have not only the goodwill, you will have to establish that by reason of the goodwill that you have established in your goods, there is a possibility of confusion by the respondent manufacturing goods with the same trade dress or similar trade dress. And there, my lord, I relied upon that judgment of Supreme Court which says that defendant will escape liability if there is any added matter to the trade dress sufficient to distinguish it. I said that there is, my lord, there is, my lord, it is not a simple added matter. It's a huge added matter, the name and the name of the manufacturer, which will definitely, my lord, not going to mislead any person to, my lord, different.
No yellow, sir, no yellow. No yellow and no car. There is no car here. There is a light, but no car.
It is.
And there's one more thing. So you need to show me the sides. I'll just show you. Get me the other. Right. The side is distinct. You see this?
No. It's totally different. Excepting for the color, there is nothing similar.
No. Yellow splash. Splash is distinct. You see the mileage, sir. This year. the yellow mileage and the car. There is no car.
Well, if your lordship kindly takes these two and kindly see the difference in this. Here, my lord, it is written excite mileage. Then, my lord, there's the photograph of a car and quite a fashionable car for that. And my lord, there is no and there is yellow and there is white. And there is no, my lord, no name of the manufacturer printed here. Whereas, my lord, they kindly see
You just pass it.
the possibility of confusion. That is what I am on.
So then these two, they are totally distinct. Here, see, this is to be open. The handle is distinct. Sides are totally distinct. These are ribbed, ribbed at the top also. So completely. You see this border, sir? Border is ribbed. And X-sides. That's horizontal lines. Horizontal lines into vertical lines. It is vertical lines. That is horizontal. Put it like this. It showed like this and if this means you can't even if you see the colors are so distinct. There's black, there's a car, there's yellow, and this is completely different. Battery's power is fire. Fire. And if you see the power of two handles, single handling is totally distinct. Would you like to point out this difference?
My lord, also kindly note that there are two handles here in Elito, in our battery. There is one handle there. Number two, kindly see, my lord, the side. There is this kind of
ribbing.
Yes, a ribbing. Whereas, my lord, there is no such ribbing in Excite. My lord, kindly see that here your lordship sees this as the horizon. These are perpendicular line. Whereas this is a horizontal.
Yes, horizontal. Yes.
Yeah, horizontal. Well, there is so much of difference in this. So, my lord, quite apart from anything else, I submit to your lordship, my lord, and this is my basic point which I submitted, that no person will go into the shop room and buy a battery on the basis of the color. And if the color has not assumed that kind of an importance, significance, my lord, I respectfully submit to your lordship, the first issue with regard to goodwill attached to the color has also not been established.
On one side, there is Excite written on top, here, and here. I'll just show on this, sir.
Come back to it.
Yes, fair enough.
Yes. I will request your lordship to come to paragraph 31 at page 26 of the impugned judgment. Keeping this in mind, my lord, kindly take this paragraph. I said there is error in this judgment in this.
The learned judge got a little annoyed because the defendant did not answer a query as to why this color scheme was adopted.
We answered it with affidavit. And that has been quoted by the learned judge. Why should I not answer this? I said, when this question was asked of me, I say it is not necessary to explain, even though some of the judgments had said so, but in the facts of this instant case, it is not necessary. But in any event, we have given explanation. Kindly, my lord, come to paragraph 31.
You put it in our written solution.
Yes, I shall come to that affidavit. I shall show that affidavit. My lord, kindly come to para 31 first. There exists unexpected and unexplained similarity in the two products, which cannot be overlooked. Obviously, there is a deliberate attempt to steer close towards approximation of the petitioner's get-up and trade dress. I pause here for a moment. I shall satisfy your lordship. The court say that even if there is this close similarity, that doesn't matter at all, unless there is this confusion. I shall show your lordship that particular judgment. Very same, this language has been used. Kindly, my lord, see, in this context, the decision of Cadbury Schweppes and Pub Squash 1981 26 RPC cited by the respondent is distinguishable. We cited this judgment to controvert this. And then how does it distinguish? The disputes between the parties pertain to advertisement campaigns. The appellant admitted that there was no significant deception or confusion and was unable on evidence to substantiate the fact that the public associated yellow cans with its product solo. I shall show to your lordship the judgment does not say so. Then, my lord, para 32. Ultimately, it is the cumulative and wholesome effect of the detailed resemblances in color red accepted. Now, my lord, words EL. Kindly, my lord, make note of it. If there is no EL here at all in the excite, and the shattered O device. Shattered O is not there in excite. The shattered O is there here in my product, Elito.
It's a lightning bolt, which is
It is not really shattered O in that sense. Lord, this is with regard to electricity. So, my lord, this O is having this lightning, the electricity, and that this is what we have done. And this is not there in excite at all on the box. So, my lord, it's a case of, my lord, passing off. In a case of passing off, one has to look into what are the similarities of the trade dress.
This is a dissimilarity.
Or similarity and consequently.
This shattered O is a dissimilarity.
Yes. And, my lord, this is kindly known that. Sorry, your lordship kindly comes back to paragraph 32 once more. Ultimately, it is the cumulative and wholesome effect. Cumulative and wholesome effect of the detailed resemblances. What are the detailed resemblances? Color red, accepted. Word EL, where is EL? And shadow, where is shadow in excite? All of which form to be a prominent, integral, and distinctive part of the petitioner's trade dress. I submit to your lordship that the judgment is wrong because it has proceeded on completely wrong appreciation of facts. There is no, my lord, words EL, no shadow device. And on the basis of this, the learned judge has made this cumulative and wholesome effect. And, my lord, tried to identify one with the other. This is wrong. Then, my lord, kindly see, which forms it to be a prominent, integral, and distinctive part of the petitioner's trade dress. Not so. And get up, taken holistically, which prima facie contribute to a positive case of grant of protective orders. If the basis of the protective order is this, and if this is incorrect, I respectfully submit to your lordship the ultimate conclusion cannot be sustained. Then, my lord, kindly take this. The court has taken note of this Cadbury Schweppes. And, my lord, there, in respect of this, the court has said this. Sorry. It's well, at this stage, since Cadbury Schweppes is there here, I will show your lordship that judgment first. Before, my lord, I come to Cadbury Schweppes. My lord, kindly take, my lord, a judgment of Schweppes versus Gibbons. And my lord, this judgment is very important, and I emphasize on this particular judgment more than once. This is reported in Schweppes and Gibbons. Well, this is reported in
Volume 22, RPC, page 601.
601. My lord, I will give your lordship a copy. Give me a copy, another copy.
Give it, sir. Versus given.
नहीं पहले
You got a copy?
Sir, they're getting.
এই বইগুলো আনেনি?
I can hand up my copy.
So just wait for a minute. Do you have a marked copy of your?
Yes, sir. But
There's one copy.
which is unmarked.
Lord, we'll hand over the one.
we don't mind a marked copy at all.
There's one copy.
My lord, we'll give my lord an unmarked copy though. Come on, hurry up.
Thank you.
এইটাই the problem, I know.
My lord, this was cited before the trial court.
Thank you.
My lord, I have two unmarked copies, my lord. We are relying on it also.
Given the
Oh.
one unmarked copy I have given.
আচ্ছা, ঠিক আছে। রাখো, and
Lordship,
ensure
can
there's
you-
another.
Page 602.
I just checked up. We are hearing out the appeal. That was the
Yes,
understanding.
that's the order, man.
The order here. Because my lord, we have got 2 months time
Yes.
under this order itself.
Yes.
So by that time, matter can be heard. Kindly come to page 602.
My lord, there's a Bengali expression, my lord. And my lord, it's all being said in a lighter vein. So my lord, my learned friend, my lord, won't, my lord.
No, I will not mind at all. You say whatever you like.
No, my lord. Ainer Fuara. My lord, it was what happened, my lord, before. You'll kindly see the number of cases, my lord, which have been
Quite a
cited.
few of them cited. My lord, both of us did that.
For the benefit of Mr. Luthra, please translate.
I was waiting for my learned friends to be able to.
Fountain of law is what happened.
Lordship will kindly come to page 602. It says that the following is a representation, second paragraph, in black and white of the plaintiff's level.
My lord, your lordships, my lord, have been introduced, my lord, to, my lord, your lordships know, my lord, a lot of the lawyers who are, my lord, coming, my lord, from outside. My lord, one person I want to introduce, my lord, who's one of the finest, my lord, IP lawyers, my lord, in the country, Mr. Adarsh Ramunajan, who's assisted me, my lord, innumerable cases, including, my lord, the major Monsanto litigation. My lord, he is a patent expert. He's also a published author. So I thought, my lord, I should, my lord, though he's on the other side, on the wrong side, my lord, I thought, my lord, I must introduce him.
He is on your right side.
True.
He's on your right side. He's right.
My lord, he was of great help to me, assistance to me in the trial court also.
Who is Gopal? Krishna. Very well. Let's get back.
And my lord, we have, my lord, a next generation also, my lord, who Mr. Luthra should introduce.
I'm accompanied by Vasundhara Bhakru, my daughter-in-law, who's here. She is a lawyer. She does work on the IP side. So I had the assistance. I requested her for some assistance because I'm more or less ignorant in this field.
But I have not been introduced to
Your
daughter
daughter
also.
also. My apologies.
Even though she's assisting me in the
My apologies, sir.
No, no, Siddharth, his daughter also, why you only alone taking the credit? Daughter of, he knows.
Her father is the current Chief Justice in Karnataka, Justice Vibhu.
I see. I see. Oh, of course, I know him.
Yes.
We've met at the NJA. Okay.
My lord, he used to be, my lord, a regular junior or on the other side assisting Mr. Sarkar.
I see. I see.
Well, I was at page 602.
Yes.
The following is a representation in black and white of the plaintiff's level. In use, the ground of the level, here shown in black, was chocolate in color, and the central disc was colored red with the fountain mark and letterpress on it in black. Then, my lord, the following is a representation in black and white of the defendant's level. In use, the ground of this level, here shown in black, was chocolate in color, and the central disc and etc. similarly colored to the plaintiff's level. So these are the two levels, and the similarity in the two levels have been mentioned here. Now, my lord, Lordship will be pleased to come to the judgment. Lord Halsbury's judgment is at page 606. It says, in this case, there seems to me to be a very bold endeavor to upset by this appeal the judgment of all the learned judges who have had this question before them. I confess myself, I have not been able to quite understand the proposition which was sought to be put before us. I should have thought, if you looked at the two bottles together, no human being could have mistaken the one for the other. This is the one I was quoting before, Lordship. Well, these are the two your Lordship has been pleased to see. The color was similar, chocolate and yellow. And then, my lord, it goes on to say, I should have thought Gibbons and Schweppes are equally impossible to be confounded with each other. But if I may use this expression, in the facts of this case, Excite and Elito are equally impossible to be confounded with each other. I can quite understand a case in which, although colorably a defendant has introduced his own name, yet the nature of the wrappings up, the nature of the package itself, or as in this case, the shape of the bottles may all have been so closely imitated that the mere introduction of some distinctive mark to which no ordinary observer would have applied his mind, my lord, kindly note that, to which no ordinary observer would have applied his mind, will not get rid of the obvious intention to pass the one goods off as the other. But to apply the proposition to this case appears to me to be a little short of ridiculous. The name Gibbons is as plainly placed upon the bottle as it can possibly be. And it is in the place where Schweppes is on the bottle in the other case, exactly the same as ours. Inasmuch as you are certainly not to impute fraud without proof, you are not to suggest that people are fraudulently committing some commercial trick without sufficient evidence. And I cannot conceive here how anybody could gravely argue that the one thing could be mistaken for the other by anybody who looked at it. Really, the argument which has been pressed upon your lordship's attention is something of this character. And then, my lord, the argument has been given. This is a common soda water bottle. The barmen at refreshment houses or public houses are so careless that they may take up one bottle instead of the another, and they really do not look at either, but take the first that comes to hand. That is the sort of thing that is suggested. What has that to do with it? The question that we have to determine is whether in selling the bottle, a person is likely to be deceived. by the resemblance of one thing to the other. And if a person is so careless that he does not look and does not, as I think Lord Macnaghten described it in another case, treat the label fairly, but takes the bottle without sufficient consideration and without reading what is written very plainly, indeed upon the face of the label on which the trader has placed his own name, then you certainly cannot say he is deceived. In fact, he does not care which it is.
Can I just come back in a moment, my lord? I'll just come.
That would be the true inference which I think a person would draw from conduct so described. The next paragraph. The whole question in these cases is whether the thing taken in its entirety, kindly note these words, looking at the whole thing is such that in the ordinary course of things, a person with reasonable apprehension and with proper eyesight would be deceived. Looking at it in this way, it seems to me it is only necessary here to put the two things side by side to say that if you do look and if you do treat the two labels fairly, no human being could be deceived. I don't think any stronger language could have been used in a judgment of the House of Lords.
Yes, all the fallacies was
Indeed, in corroboration of that view, I may say that in this case, there is not a particle of evidence that any human being ever was deceived. My lord, in the facts of our case, my lord, there is not a single evidence. I would have expected, my lord, some kind of an affidavit on behalf of the plaintiff had been given, saying some purchaser, saying that I walked into the shop room, I found a red battery, I thought it was Excite battery, by mistake I bought Elito battery. Nothing. And this is, my lord, what it is. There is not a particle of evidence that any human being ever was deceived. I tell you, Lordship, the reliance for this. I tell you, Lordship, what was relied upon by the court, and the court was impressed by that. This, your Lordship will please to find in the judgment itself. I think, in all fairness, I should point it out to your Lordship. Kindly, my lord, come to page 6 of the judgment. This is what, my lord, the court said that you yourself knew that red was distinguishable. I mean, this is a distinguishing feature, and you yourself had treated like this. But what happened was this: during, my lord, the COVID period, your Lordship knows that red and green, these signs were used, and the areas where, my lord, the COVID was in a very virulent form, my lord, that area used to be marked with red, so that people were prevented from going into that
Is
area.
red zone, orange zone, green
And
zone.
green zone. Now, my lord, we took at that particular point of time, the defendant, appellant before Lordship, had taken advantage of that by way of a sort of advertisement gimmick. This is what it is, page 6. Kindly come to that. The court had, in this context, some of the relevant advertisement of the respondent are set out below. If it is not red, it is not safe. If it is red, it is not safe. And then, my lord, let's turn to the nation from red to green to last long really. And then let's turn the nation from red to green to last long really long. And this is, my lord, this was what was done. This is what, my lord, impressed the court. The court said that you yourself had taken as if the red is identified to the Excite people.
Public also says.
And green is yours. In fact, my lord, I shall tell your lordship the factual background of it. We used to manufacture, my lord, and we still manufacture Amaron battery, which is, my lord, is very. This is a there is a competition between Excite and Amaron in the market. Of course, they are ahead of us, but this is one such. And Amaron batteries were green. Excite batteries were red. So at this point of time, taking advantage of this COVID my lord, the indications, my lord, we made this publicity. So court, my lord, relied upon this to say that you yourself have accepted as if the red is them and green is you.
There's no mention of exide here.
My lord, of course, there is no mention of exide here. With the Amaron is mentioned, but exide is not mentioned. But this is what it is. This is what had been taken note of by the court. Keeping this in mind, my lord, your lordship.
This can be distinguished because of the demarcation can be like.
No, we shall come to that. No, first of all, my lord, this is what it is, and my lord, this is what had been taken note of here in the first place. Okay, where is that particular paragraph that he has said that it requires reconsideration?
This one may very well require it.
Yeah. Well, kindly come back again to the judgment of the House of Lords. This Schweppes is given against. Yes, coming back to that. I have come up to my lord. There is not a particle of evidence that any human being ever was deceived. The notion that one could supply evidence of that sort, because in collecting bottles, 2 bottles other than Schweppes were included in a mass of bottles collected from a public house, is somewhat absurd. The real truth is that here, looking at the whole thing, there is such a distinctive mark, negativing its being Schweppes, that it would be, to my mind, absolutely absurd to suppose that anybody treating the label fairly could be deceived. That is the whole substance of the case. My lord, in the instant case, apart from that particular, which I showed to your lordship in page 6, there was nothing on record to show that anybody was deceived or anybody identified, my lord, the red battery with the exide battery. None whatsoever. I say that without any fear of contradiction. I expected some kind of an evidence, nothing came. Then, my lord, kindly come to the next paragraph. The reason why I'm reading it, my lord, the court had made a comment on this. I entirely agree with Justice Warrington, whose judgment I do not propose to repeat, and with the Lord Justice Roma and Lord Justice Kozansardi, that there is really no ground whatever for this imputation upon the respondent, and I am therefore of opinion that this appeal ought to be dismissed. I have some difficulty in following what Lord Justice Vaughan Williams really intended to convey. Whatever it was, however, it was not sufficiently distinct to enable me to deal with it. All I can say is that with the judgments that have been delivered by the other learned judges, I entirely and heartily concur, and I move your lordships that this appeal be dismissed. Then Lord Robertson is saying, my lords, I entirely agree. My judgment is, of course, given on the evidence before the House. In that evidence, there is no case at all of actual mistake on the part of the ultimate purchaser. My lord, we are concerned with the ultimate purchaser. So whatever may be by advertisement, that could not have weight with the court. Accordingly, the case is rested solely upon the comparison between the 2 labels. I am requesting your lordship to do the same here. Now, even if this comparison between the 2 labels were just criterion, I think that this comparison, I think the difference between the 2 labels is not merely material, but pictorially effective. In fact, no one who has had the 2 bottles in his hands could be deceived. The appellant's case accordingly is what on the evidence is merely conjectural, that a person seeing a bottle opened by another would not notice the difference. This again, however, rests on the fallacious view that what is seen is merely the label. In fact, the bottle is what is seen, not the label alone. And while on the bottle of the appellants, there are always 2 labels. On the bottle of the respondent, where there is only one, either on the neck or on the cork. My lords, I agree generally with the view stated by Lord Roma. Then Lord Lindley also says the same thing. My lord, and it says that it appears to me that the real answer to the appellant's case is this, that they invite your lordships to look not at the whole get-up, but at the part of the get-up which suits their case. And this is what I am respectfully submitting the petitioners have done in the trial court. Now, my lord, this judgment is loud and clear. There is no ambiguity in this judgment. If there is, my lord, the decision is that if in the two get-ups you see there is something which completely distinguishes one from the other, then the basic get-up on which you are relying becomes immaterial. This is what it says. So, my lord, this judgment had come for criticism in the impugned judgment. Kindly come to page 27. About the middle of that paragraph, the primary question was whether a barman would be deceived by the label. There was no dispute as to the fact that the soda bottles were strikingly identical. However, in view of the name explicitly appearing in the rival bottle, as a matter of fact, it was found that there was no question of passing off. So, my lord, I say that kindly apply this in the facts of our case. The name of explicitly appearing on the two batteries, in the rival batteries, as a matter of fact, it should have been found that there was no question of passing off. And then the next sentence. This decision may very well require reconsideration in the light of the pronouncements in Cadila Healthcare and, my lord, Eurosolo Energy System Limited. I shall place both these judgments. I do not think there is anything contrary. On the contrary, my lord, kindly come to one paragraph in this judgment itself. Lordship will kindly come to page, and I say that this is good enough for me. The court has relied upon a Supreme Court judgment and very well-known Supreme Court judgment, that, my lord, Navaratna's case, AR 1965 Supreme Court. Kindly come to paragraph 16 at page 11. I am criticizing the judgment, my lord, with the greatest of deference to the learned judge on the basis of the judgment itself. Kaviraj Pandit Durgadat Sharma versus Navaratna Pharmaceuticals, a very well-known judgment, my lord. We have studied it, my lord, when we were students, not students, just about joined the profession.
Where is a student in this profession?
Tumi students,
No, we are always students in this profession.
in that sense. My lord, it says this: while an action for passing off is a common law remedy, being in substance an action for deceit, that is, a passing off by a person of his own goods as those of another, that is not the gist of an action for infringement. The action for infringement is a statutory remedy conferred on the registered proprietor of a registered trademark for the vindication of the exclusive right to the use of the trademark in relation to those goods. Section 21. The use by the defendant of the trademark of the plaintiff is not essential in an action for passing off, but is the sine qua non in the case of an action for infringement. No doubt whether evidence in respect of passing off consists merely of the colorable use of a registered trademark, the essential features of both the actions might coincide in the sense that what would be a colorable imitation of a trademark in a passing off action would also be such in an action for infringement of the same trademark. But there, the correspondence between the two, the correspondence between the two causes
ceases.
A line has been omitted.
Ceases.
In an action for infringement of plaintiff, the plaintiff must no doubt make out a case that the use of the defendant's mark is likely to deceive. But where the similarity between the plaintiff's and the defendant's mark is so close, either visually, phonetically, or otherwise, and the court reaches the conclusion that there is an imitation, no further evidence is required to establish that the plaintiff's rights are violated. Expressed in another way, if the essential features of the trademark have been adopted by the defendant, the fact that the get up, packing, and other writing on marks on the goods or on the packet in which he offers his goods for the sale show marked difference or indicate clearly a trade origin different from that of the registered proprietor of the mark would be immaterial. Whereas, well, this is the important part I am emphasizing. Whereas in the case of passing off, the defendant may escape liability if he can show that the added matter is sufficient to distinguish his goods from those of the plaintiff. This is exactly what my Lord Shoaib has said, House of Lords. And the learned judge says that it requires reconsideration. I said, this is the law. That if the trade dress is such, is absolutely similar to each other, but if there is a distinguishing feature on the trade dress itself, which will, my Lord, differentiate one from the other, that is good enough. Then, my Lord, this is, my Lord, it says, case of passing off, escape liability can show that the added matter is sufficient to distinguish. This is the added matter which I would have thought, my Lord, that would have been sufficient, my Lord, to deal with and dispose of the application of the petitioner. Because, my Lord, I placed and, my Lord, the court had taken note of it in the judgment itself. And the court had said, my Lord, placed these two side by side at page 6, your Lordship has been pleased to see, page 8, your Lordship has been pleased to see. Apply, my Lord, Shoaib's case, my Lord, in the facts of this case, and the facts are writ large at page 8. There are other decisions also which go to say the same thing. Oh yeah, I'm coming to that. You're quite right. I should. No, I should do that.
No, but I'm not only learn.
My Lord, in this connection, my Lord, I will respectfully
that my added matter is also different. We're considering it as the permissive.
My Lord, there is no finding in this particular judgment, and unfortunately, I could not find any. My learned friend will point out if there is. That, my Lord, the court has come to the conclusion that what is written on the battery, both are read. And these are insignificant. In other words, if the court has not come to the conclusion that even though these two batteries, two sets of batteries are marked LE2 and Excite, but they're written in such a way it is not important, or it is not something which is insignificant. It is something which could not have attracted the attention
So
of.
what you are saying, the learned judge has not come to a finding that the distinguishing features are insignificant.
The distinguishing features have not been taken note of.
Glossed over completely.
Completely glossed over. And this is, my Lord, perversity in my very respectful submission in the judgment, because, my Lord, very essential evidence had been ignored.
So you can point out to him that the image itself that he shows makes it very clear how distinct they are, which we have now shown you is you.
And your Lordship, my Lord, again come back, my learned friend rightly points out that if you see these two things, my Lord, the fact that they are totally different from each other, and, my Lord, any person who would have gone and bind, there would not be any unwary customer who would have got confused by reason of the fact that they both are red. And this, my Lord, had been also, this is one thing, my Lord, I wanted to point out to your Lordship. The learned judge has been pleased to say that there was a bold enough to say, find out that particular paragraph where he has said that get up matters are no, where he has said that had been bold and enough to say that I did not answer the query. Yes, yes, kindly come to para 22 once more. Kindly come to para 22. This, I submit to your lordship, perhaps was not quite correct. With the greatest of deference to the learned judge, in response to a query from the court as to why the color red, the respondent had retorted that there is no obligation for them to explain why red. Well, I would never say that much. But I was arguing the matter. I would never tell the court that I have no obligation to tell your lordship as to why this red. And, যাই হোক ভাই, আমি সুদীপ্তর against কিছু। The reply smacked of arrogance, not because of any inarticulate premises, but because of the law demanded an answer. It is a question which falls to be asked and answered. And my lord, Lord Justice Kerr's judgment has been cited. The doubtful explanation given by the respondent for the choice of the word sifi, coupled with reputation of the appellant, can rationally lead us to the conclusion that the respondent was seeking to cash in on the appellant's reputation. There is no explanation. Well, this is from the SIFINET solution, 2004-6 Supreme Court cases. That's been quoted. There is no explanation as to why they suddenly adopted the blue color, and the adoption appears to be dishonest with an intention. Use of the color blue as the background in the wrapper of the last straw of the camel. It's ITC. There is no conceivable reason for the defendant to have adopted such a label and trade dress, one so usually and structurally similar to the plaintiffs. That is, my lord, International Private Limited by Sanwal Chan. Finally, the intent of the defendant in adopting trade dress is a critical factor, since if the trade dress were adopted with the intent of deriving benefit from the reputation of the plaintiff, that fact alone may be sufficient to justify the inference confusing. Fortunately, my lord, it's paragraph 23. But this paragraph 23 is very important. There is also, again, my lord, I'm sorry to use that expression, perversity has come in. Kindly, my lord, come to paragraph 23. After saying that boldly and arrogantly, we have refused to explain the obligation. Saying that there is no obligation to explain why red. Then paragraph 23. Fortunately or unfortunately, the affidavit filed by the respondent proffered or at least attempted to explain as to why the change of color. So, my lord, how is it that the court has said that I did not say that? I placed that particular affidavit, and that has been quoted here. For convenience, the relevant paragraph in affidavit in opposition filed by the respondent are reproduced here in below. Para 18. I state that the defendant launched the brand Elito first in international market only as it did not want to disrupt the market of their already established brand Amaron at so and so in India. However, when the COVID-19 restrictions were getting lifted, there was a rise in demand for automotive batteries, and the defendant decided to tap this opportunity and launch its brand Elito in India as well. Then 19. I state that the defendant had received some feedback from the master distributor regarding performance of the blue-colored Elito products in the international market. But in the international market, only blue-colored Elito was launched, which inter alia included that A, the E in Elito without the vertical line is difficult for the customers to understand, and they are unable to pronounce the brand name. Then B, the blue color of batteries was not making it stand out in the clutter. In the clutter, my lord, where there is red, there is yellow, the blue becomes insignificant. And it was suggested that the brand color be changed and any other bright and vibrant color. In this regard, a copy of the affidavit dated 24/3/25, executed by Mr. Jindal, Chief Marketing Officer of the defendant company, is annexed. In this, then para 24. In this connection, the relevant portion of the above affidavit of the marketing officer is set out below. Para 3. I state that after the launch of the brand Elito in the year 2020 in the international market, except India, there were various meetings held on the product performance of the brand Elito between the distributor and the company at the corporate office of the company at Hyderabad, India, between December 2021 and September 2022. In these meetings, the distributor was represented by the authorized representative, Mr. Ganesh Swaminathan, and the company was represented by me. During the above said meetings, various discussions on product performance were held between the distributor and the company, in which the distributor shared the feedbacks and received from the various dealers and customers in the international market. The feedbacks included the word E in Elito without the vertical line is difficult for the customers to understand, and they are unable to pronounce the brand name. Well, at Elito, first, my lord, this E, the perpendicular line was not there, only the parallel lines were there. So that was asked to be rectified. So that is the first one. Then the blue color of the batteries was not making it stand out in the clutter, and it was suggested to me that the brand color be changed to any other bright and vibrant color. Then 3, the COVID-19 pandemic had impacted the sale of the automotive batteries in the international market, and the estimated targets for brand Elito were not being met. The brand Elito had to be launched in more countries for global expansion. Then 5, the product quality and after-sales performance in the international market was also discussed. Then para 25, the court's observation. In brief, the respondent at the interim stage, keeping in mind that this is a commercial suit, relied on a self-serving affidavit. Well, the affidavits are generally self-serving. It can't be somebody else serving somebody else of its own. And relied on a self-serving affidavit of its own marketing officer to contend that though it had launched Elito in blue color in 2020, later, insofar as feedback received from an overseas dealer, so-and-so, that blue did not stand out in the clutter, a more bright and vibrant color was desirable. Despite there being no affidavit nor letter of Asian Africa in support of the above suggestion, there is also an inherent contradiction and irreconcilability in the case of the respondent, inasmuch as, on the one hand, it alleges that the color has no role to play in such matter, and on the other hand, the respondent has been compelled to bring about a change only on the basis that blue did not stand out in the clutter, and a more bright and vibrant color was necessary. Resultantly, the change brought about by the respondent was as follows. Elito blue became Elito. Insofar as blue Elito is concerned, in India, we never launched that, never. Elito blue was in international market only, except in India. And for the first time when Elito was launched in India, that is, my lord, in the month of April 2023. April 2023, and we have given, my lord, volumes, 3 volumes of, my lord, the invoices, affidavits, etc., and so also, my lord, the accounts in respect of that.
Whatever the written submissions we put this issue regarding the affidavit in, that's about the written submissions.
And the suit was filed this year.
The suit was filed in 2000.
Yes, right now.
Yes, 25.
March 25. So this is what we said.
And my lord, on the basis of that, my lord, we had made an application for revocation of the leave under Section 12A. That application was heard by the court also. And in fact, we insisted that that application should be heard first before this one. The court heard that application, but judgment was delivered on 2 matters, my lord, on the same.
That is pending.
No, that has been that has been disposed of.
Revocation of 12A has been rejected.
Yes. And together, my lord, the judgment was delivered. First, my lord, rejection of my application for revocation, and then, my lord, this particular application. This happened. So, my lord, what I'm saying is here is this, and we had sufficient material to, my lord, establish before the court that this particular product, Elito, was launched as early as in April 2023 in Indian market. And, my lord, this is not an oral verbal statement only. Volumes of, my lord, invoices.
There is no discussion of that here.
No, nothing absolutely.
The judgment is to add. This is at internal page 25.
My lord,
so I'm just
thank you. Thank you. My lord, kindly come to page 25 of the judgment. My lord, I will place para 30, the whole of para 30. Let me place it in color. I think it's better. It is true, para 30 at page 25, that it is not a prerequisite to liability that the plaintiff must be able to show that the defendant intended to pass off their goods as that of the plaintiff. It is equally true, as argued by the respondent, that motive cannot per se afford a cause of action. So, my lord, on this I have succeeded. However, ill motive or bad faith can always tilt the scale in such matters in establishing the probability of deception. A conscious decision to live so dangerously, my lord, it reminds me of my lord 007. A conscious decision to live so dangerously close to the petitioner is impermissible. In cases, my lord, I don't think, my lord, the petitioners are so untouchable as not to be able to live close to them. In cases where there is intent to deceive, a court would more readily infer that the object has been achieved. In cases where there is intent to deceive, so therefore the court is first presuming that there is intent to deceive, and then, my lord, it is coming to the conclusion the court would more readily infer that the object has been achieved. That is, the intent to deceive ripens into actual deceit. This is not the sort of conduct which, even at the interlocutory stage, is to be disregarded. What was the respondent thinking in effecting such changes? In some ways, the entire exercise undertaken by the respondent can best be described as ill-advised, unimaginative, and presumptuous. One would not be mistaken to conclude that the respondent had only the petitioner and its product in mind, and was solely inspired by the petitioner in causing such changes. To add, the false claim of user from April 2023, I could not follow this sentence exactly. To add, the false claim of user from April 2023, the court did not take note of these 3 volumes of invoices. I shall show to your lordship. 14 to 16, volume 14 to 16 before the trial court, only invoice. And this before this court. April, false representation made regarding the entity named Unifieder, removal of incriminating evidence during hearing, that is posts on Facebook. Well, I don't understand this. Website so and so showing blue batteries taken down. The LinkedIn Unifieder, which though placed at the time of the opening of submission, had been taken down during the course of hearing, and the self-contradictory statements in the affidavit all suggest bad faith, with the ultimate aim to create confusing similarity. Taken as a whole, the respondent as a trade rival has, in changing the trade dress, miscalculated the degree of resemblances. Keeping the above principles in mind and in balancing competing interests, the Rubicon of Lakshman Rekha has been crossed. So, my lord, it seemed, my lord, somehow the learned judge was had taken some kind of a view as against my client, that this entire exercise of going into red battery is a mala fide move on our part. We are trying to encash on the so-called popularity of Excite. This is what the court from the very beginning. So I had, I'm sorry to say, I had trouble, my lord, in making my submissions, but I did make my submissions. But then the court had from the very beginning, and the court had been repeatedly asking me, why is it that you made that advertisement that red is the red is dangerous, go for green, etc. Now I tried to explain in my own humble way as to why it is so. And then, my lord, I relied upon the affidavit for the purpose of showing that it was on the basis of expert advice that we changed this color. Now, my lord, that did not find favor with the learned judge, as a result of which, my lord, we suffered this order of injunction. But my lord, I will submit to your lordship, and my lord, on the next occasion, my lord.
This order was passed after exchange of affidavits.
Yes, yes. And my lord, exchange of affidavits, my lord, in which one I came out with all my evidence, whatever was required, including, my lord, the annual turnover, my lord, the annual reports, the balance sheets. These were all. And my lord, I shall on the next occasion. I
want you to show before we end. That's para 19 of the written submission, because that is in line with what you
Para 19 of the written submission.
Not just para. One thing we'd like your lordship to see is para 19 of our written submissions, volume 29, 4224. So this one, the reason for adoption of right.
And my lord, there in the we have quoted
volume 29.
Volume 29, page 4224. This is
well, I wish, my lord, this submission of ours had been considered and rejected. Unfortunately, these were not considered by the court.
Can I get the volume 44? Mine is there. Some mine is there.
Yeah, it is here.
I'll keep it open, sir.
It is here.
It's open for you.
And in fact, it looks much better than my copy.
I've been telling you, sir.
You have not been able to teach me all this.
I learned in COVID because I used to be locked up.
When would you like to come back?
224.
When would you like to come back?
Whenever.
Whatever you say.
Excepting tomorrow. Tomorrow, my brother will have to go away to
No,
Bhopal.
my learned friend is going back.
I will go back.
When will you come, Mr. Luthra? Monday or Tuesday or?
My lord, Monday to, my lord, Thursday I was in difficulty. I had indicated, my lord.
We'll do something. Just give me a moment, Lord. I'll just try and.
The next week after?
Monday to Thursday, Lord, your lordship is saying.
Monday to Thursday, Mr. Mukherjee is in difficulty.
Fair enough, Lord. Fair enough. Just give me a moment.
Week after then?
So just
Subject to
Friday. Let me just see if I can do Friday next.
My lord, I would suggest, my lord, Mr. Luthra comes on a Friday and goes back on a Saturday.
I wish I could. Lord, would Friday the 29th?
29 figure.
Friday would be inconvenient for your lord.
yes. What about the week after? Second or third or fourth, I was subject to the.
I'll tell you what, Mr. Luthra, we would prefer any day but Friday, because what happens on a Friday, invariably, the courts rise early.
Thursday the 4th.
Thursday is better.
Wednesday the 4th. Thursday the 4th.
Yes.
Thursday the 4th.
Yes. Hey,
ঠিক আছে
দেখেছো? দেখেছো? Very well. বলছি নেই কিছু? বেঞ্চ কিছু হয়ে গেছে Thursday? Yeah.
What would suit your lordship?
Fourth, you said?
4th if convenient, Lord. I must point out 5th is Eid. So would your lordship have the similar difficulty?
No.
Fair enough.
No problem at all.
So fourth, my lord, kindly give it time.
Yes. 3 p.m. Like today?
3 p.m. is all right, or 2 p.m.
Oh, yes. We do to show. 2 p.m.
At 2 p.m.
2 p.m.
We'll tell you why. Thursday will be a deemed Friday,
Yes, Lord.
and therefore possibility.
My lord, then have it on 11th, please. If 10th or 11th is
2 p.m.
2 p.m. I'm not, because it's a deemed Friday. I thought maybe.
No, the court may rise at 3:30, not before 3:30.
Understood. So 2 p.m. 4th.
Is it okay? All right with you? Please check up. Mr. Joyanto Mitra Kumar, learned senior counsel representing the appellant, opens his submission but does not.
Banerjee is not there. Sure.
On 4th, Mr.
No,
They won't conclude on that day also, I think.
5th is a holiday, so I have
Of
to.
course, other jurisdiction.
Other jurisdiction, other jurisdiction.
Yeah.
You, Dara.
Well, Lord, what is happening is the single judge has given us 2 months to dispose of stocks. What we are saying is not. There is a case which my learned senior has made out. Not that.
No, I'm sure the other side, Mr. Mukherjee, will not, since we are hearing the appeal.
Let me make that.
No, my lord, that's not needed, my lord. That will create a problem.
Tell your lordship,
My lord,
my lord, then let me tell your lordship something, Lord, which my learned senior and I had conferred. They've been granted an injunction. They've asked for an injunction for their own products. The prayer is for their own products. They've been granted an injunction for my
No,
products.
I have prayer B also.
I'm
Prayer
sorry,
B
sir.
covers it.
My prayer, I'll show your lordship, but prayer A is a problem. They cannot get over it because if your lordship sees that entire line of products, they've asked for an injunction for their own products. How could this? And the suit is defective. We are
Suit
moving
is
an
not
application
defective.
for
Prayer B is there.
You are before us. There won't be any problem. We assure you. Tell us when are you coming
But
back
I
then?
said the only reason I was making this request was because of the commercial considerations involved. Because not there's large stocks which, if assuming your lordship was to hold against us, then there are large stocks we have to deal with because there's a limitation.
We'll grant you
And-
time. If we hold against you, we'll grant you
Yes.
time.
But of course not. And if your lordship holds against me, then of course there is no difficulty. I never presume your lordship will hold it back. Why should I?
Yes, the 4th, that's final.
And I hope they'll be concluding, my lord, on that date.
No, I don't give any assurance.
That we do.
কি হচ্ছে নাকি?
September 4,
আশ্চর্য ছেলে।
2025.
That was just to, my lord, get a reaction.
এই বদমাইশ এরে, কি আশ্চর্য লোক।
Para 19, you said.
No,
Prayer A,
No, no, no.
no, of the note, para 19.
submission, Lord. Oh, written submission until your lordship sees 19. Yeah, 4224, Lord. 4224. Just see that for a moment. Para 19. Now you'll see that the reason for adoption of red color, although provided in the affidavit of Maharaja's chief marketing officer, is irrelevant, especially since Exide has failed to establish that it has acquired distinctiveness in the red color itself, such that a potential customer would assume that any red automotive battery, even if it does not contain trademark, is an Exide battery. But this, irrespective of anything that may be written, example, even if the source identifier of another significant battery is clearly and conspicuously written on the red,
That's an
customer
argument.
would still think that the said battery is an Exide. In any event, no likelihood of deception, especially given in the name. So, not the point is, the word is irrelevant. So, our case was the reason for adoption, though provided, is relevant. So, it's not a case of arrogance. And if I may just point out one thing, practically, if my lord just remembers, we have till about 15-20 years ago, we used white batteries. There was no color because they needed distilled water. This whole issue of color is something which my learned senior will completely show that it is completely a chimera which has been created by Exide, and everybody is using every color. They've used every color. It's not that they use green, which is supposed to be one of my brand's principal colors, and now they want us to block us completely from red.
So it's not is it a colorable exercise of power? Something.
Well, I'll hold my horses
They
today.
seem to be seeing the color red everywhere.
Thank you.
Good.
No.